guys. Although sometimes I think our Facebook people like to see the puppies.
I bet. YouTube.
Oh, YouTube, I'm sorry. That's right, YouTube.
They're letting 2,000 fans into the garden tonight.
Oh, we are playing tonight, finally?
Well, they got to pass some kind of protocol practice this morning, but if
Okay.
they pass, but 2,000 fans are going.
Wow.
Is one of them you?
Well, I'm here in Augusta, aren't I?
Oh, yeah.
I'm working on later in the year for some baseball. But,
I heard.
Baseball sounds even better.
yeah, we hopefully they'll come through. I've already paid for the tickets, so it'd be nice if they honor them.
Yes.
My wife and I bought tickets for May 31st, and luckily she went on the Vivid Seats website because it said the game had been canceled. Well, of course, the game hasn't been canceled. When I ordered the tickets, I called them up and asked them specifically, I don't want to tie up this kind of money if you're going to sell more seats than are allowed under the protocol. And they assured me they weren't. But that's what they did. They sold more seats than they were allowed to have. And they were going to hang on to everybody's money and offer them another event. They had, in the fine print, it said you had 10 days to get a refund. Luckily, we saw that within the 10 days, so we did get our money back. But they're really pulling some fast ones. So I reached out a little further into the season to give it a try. Going to a Mets game in September with you-know-who.
I heard.
But in Boston?
Yeah.
Very
I'm
nice.
not going down into his enemy territory. Bad enough I'm taking him.
Okay.
Good morning, everyone. It looks like we have a quorum. Sorry for the slight delay. This is the meeting of the Joint Standing Committee on the Judiciary. And this morning we have a number of work sessions that we're going to do on bills. And before we get started and dive into the work session, we'll do committee introductions. And I also wanted to go over the procedure for work sessions. We have a number of people who are in the attendee section of the meeting, and the work sessions are really our opportunity as a committee to debate the bills that are before us, hear from our legislative analyst, and vote on bills. We don't have members of the public appear like they do during our bill hearings, but we may call on those who are in the attendee space if we have questions for them. And with that, we will begin with our committee introductions. And today we'll start with Representative Babbage.
Well, I'm on. Thank you very much, Madam Chair. My name is Christopher Babbage, and I represent House District 8, which is about 82% of the people of Kennebunk. Good morning.
Good morning. Representative Sheehan? Oh, excuse me, Representative Reckett is next.
Thanks. I'm Lois Reckett, and I represent District 31, which is the ocean end of South Portland, and includes the entire seagull population of South Portland.
Representative Moriarty?
Good morning to all. I'm Steve Moriarty from District 45, which is Cumberland and part of Gray.
Thank you. Representative Sheehan?
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you. Representative Libby?
Thank you, Madam Chair. My name is Laurel Libby, and I live in Auburn. I represent District 64, which is part of Auburn and all of Minot.
Thank you. And Representative Poirier?
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thanks, Representative Thorne.
Good morning. Thank you, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a small portion of Etna up in Penobscot County.
Thanks, and Representative Evangelos.
Thank you, Senator Carney. Good morning, everyone. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you, Representative Newell.
Good morning. Thank you, Madam Chair. My name is Rena Newell, and I am the Passamaquoddy Tribal Representative.
Thank you. And I'm Ann Carney. I represent Senate District 29, which is South Portland, also with a robust seagull population, Cape Elizabeth, and part of Scarborough. And we have some other committee members who will probably join us at some point during the day today, but we certainly have a quorum. And we'll just wait one moment because I think Senator Keim will also want to introduce herself. And while, good morning, Senator Keim. Would you like to introduce yourself?
Morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
Thank you. And this morning, we're also joined by our committee clerk, Supi Panett, and our legislative analyst, Peggy Reinsch. And the first, yeah. And we've been requested to take one of our bills out of order, and that is the legislation related to companion animals to accommodate the sponsor schedule. We'd like to do that last. That's LD 535. Just wanted to let people know that. Okay, so the first bill that had been scheduled is LD 132, and that's been postponed. Peggy, do we need to do a tabling motion or anything on that, or are we?
No, I think if you don't open it, it's fine. You don't, we'll just reschedule it.
Perfect. All righty, so that brings us to LD 345, an act updating certain probate filing and certificate fees to reflect current costs. And Peggy, could you please take us through your analysis?
Sure. Did you want me to, you don't need me to screen share those, do you?
Committee members, is there anybody who would like a screen share of this particular bill?
No, thanks.
Okay, I'm not seeing any.
Okay, good.
Yeah.
Yeah, that way we can all see each other. So this bill, I think there were several people who were actually requested to put in this bill, and this was the first one that got printed. Most of the probate filing fees are established in statute. The last time they were amended was in 2006. And 18A was repealed and replaced by 18C, but it didn't change any of the filing fees. So if you look at the bill identifies specific filing fees for, in subsection 2, it's estates, and they're based on the value of the estate. That's what the filing fee is. And then the other fees that are changed are certificate of appointment, petition for appointment as a guardian, petition for guardian and conservator, petition for appointment of a conservator, subsequent informal appointments, and other formal proceedings, as well as a registration of guardianship order from another state or acceptance of transfer. And the filing fee for a name change petition is also changed. So these are all increases. The fees go to the counties. The counties are actually responsible for the running of the probate courts. The counties cover all the costs of the employees, as well as the cost for appointing any attorneys or visitors in the probate court. So this bill would increase all those filing fees, and you had some testimony. I don't think you had any testimony against the bill. You had several people saying what a great idea it was. And I know that Kathy Ayers, if you have any questions, she is in the attendee room if you have questions for her.
Thank you, Peggy. Representative Evangelos?
I think everyone's done a good job on this one. And I have no further questions. If you're okay with it, I'd make a motion not to pass LD 345.
Thank you. We have a motion, and is there a second? Representative Thorne? Oh, I'm going by mechanical hands. Sorry, Representative Thorne? We're not able to hear you.
I apologize for that. I didn't realize we were going right to a vote on that. I just had a simple question, which was, what was the determining factor in these rate fees? Was it a flat percentage rate? Was it, I'm just curious.
You know, I don't have that information.
I see some doubled. Some went from $25 to $50. Others went from 40 to 60. So there's a little bit of an inconsistency in the rates, and I didn't know if they used a formula to determine the rate increase. And not that it's a determining factor, it's just a curiosity when I look at it and wonder how they came about these figures.
I don't have that information.
Okay.
If that is something that you need.
No,
you
I
can
just
ask
thought
somebody. Yeah.
I thought somebody may know the answer, but that's fine. I'm okay without it. Just curiosity more than anything. Thank you, Madam Chair.
You're welcome. Is there a second on this before we seek information related to the question? Representative Poirier? Second?
I second.
Thank you. Okay, we have a motion and a second. Time for committee discussion. And Representative Reckett, you had your hand raised earlier when Representative Thorne was speaking. Did you have an answer to that question as the bill sponsor?
Well, my question was whether Steve Gordon was in the attendee crowd today, because he's the one that actually drafted the fee schedule. He's the county commissioner in Cumberland County, and it was at his request I did this submission. And so there was a conversation between the probate clerks and the probate folks and the commissioners and the county government. So I don't know who designed the rate, but he might know, or maybe he did it himself. I have no idea.
He is not in the attendee space, but we do know that Kathy Ayers is there, and what I'll do is I'll move her, or Supi, if you could please move her onto the panel, and we can see if she knows the answer to that. Thanks, Representative Reckett.
Whoops, I get it. I moved.
Welcome, Ms. Ayers.
Oh,
it's
sorry.
good to see you.
Good to
Do
see
you
you.
have the answer to the question?
Yeah, it's not really a percentage. It was mostly looking at we try to keep the lower end of the spectrum lower. So it was not a general percentage. It was just the committee went through every line and decided where we needed to move up. Because we don't have most of our estates are on the lower end, and we don't want to increase those generally as much. So that was the only thought that went behind that. So
thank you. Let's see, Representative Thorne, was that okay? All set. Thank you very much, Ms. Ayers. And then I saw that Representative Evangelos, you had your hand raised. Did you have a question that you wanted to direct to Ms. Ayers?
Thank you, Senator Carney. No, I just during the public hearing, it was pointed out that it was reflective of their current costs, that's all.
Thanks for bringing that information forward. Representative Moriarty?
Thank you, Madam Chair. Ms. Ayers, you just mentioned that the committee went through every line. Just for the record, which committee are you speaking of?
Sure. It's a committee of the Maine Association of Registers of Probate, and they look at fees to keep them abreast. And we also have fees in rule by court rule that they keep on top of and try to figure out when we need to ask for increases. So
Okay, that's good. It's always good when we know what the source of all of this is. So that's helpful. Thank you.
Committee members, are there any other questions for Ms. Ayers? Thank you. We're gonna slide you back into the attendee space. And oh, hold on, Representative Babbage has a question. Go ahead. We're not able to hear you, Representative.
Thank you very much, Madam Chair. Ms. Ayers, good to see you, and thank you for being here. You know, I will say the list does look a little bit arbitrary, and the reason I say that is if we go up to 300,000 to 400,000 as the value of an estate, we go with a $75 increase, and then 4 to 5 a $50 increase, and then 5 to 6 a $75 increase, and then if it's up to $1 million, it's only a $50 increase. I do understand, obviously, at the bottom end, you've increased it $20 for the smallest estates. So it's 20 to 40 and 40 to 60. But is there a rhyme or reason to where it was? Because you really have adhered somewhat to where it was, and then increased it by an amount. I think that's been fairly consistent, but I do think Representative Thorne's question. I'm not interested in the increase percent, but what about the standard itself? Is there a reason that the original schedule is such as it was? Because we're building on that original schedule.
oh, why it was a scale, you mean?
Yeah, the scale doesn't seem to be proportionally more as you get larger in the area between like 300,000 and $1 million. And I just wondered if there's any reasoning for how that was determined.
I gotta say that was, I like to say that, believe it or not, that was way before my time. I've been here 28 years, but that is before my time.
Well, that's pretty good. I can't use that excuse as much as I used to be able to, but
yeah, and you'll see that over 2 million, that's when it gets more for each million over, each 500,000 over 2 million. But these estates on this end are very, very rare. I just need to reiterate that. 300,000 is under 300,000 is the norm, and more in the range of 75,000 below is the majority. So that's kind of where they put their more thought process into the amounts.
yeah, I guess. I mean, I appreciate the need for fee increases occasionally, but in the 75 to 100, you've got a $60 increase, and then for 250 to 3, you've got only a $50 increase. And it's a non-progressive, although it's small, it's a non-progressive increase schedule. But did Mr. Gordon consult with the other commissioners in coming up with a schedule? Do you know?
Well, I have to be honest. The reality of it is that the registrars did this, and if it's a mistake that it was only 50 instead of 75, that is possible. But then we voted on it as an association, and
Okay.
and then it was taken to the commissioners, because I sit on the commissioners board too.
Okay.
So it was brought to the commissioners and voted on there too. Yeah.
Okay. That's good to know. Thank you.
Yeah.
Thank you, Madam Chair.
I see that we have another question. Representative Thorne, is this a discussion or a question for Ms. Ayers? We're not able to hear you.
Madam Chair, thank you. This is along the same lines of continuation that Representative Babbage brought up, and that I wasn't going to belabor, but we're here now. So the commensurate amount, when we look at the lines that Representative Babbage was talking about, 75 to $1 million is a $50 increase. And then you go to line P, 1 million to 1.5 million, and the fee jumps up $125. And then 1.5 million to 2, the fee goes up $75. So I like to think of it in terms of the amount of work done for each amount of probate that needs to be done. But again, it's like the increments seem very random, from anywhere from $50 to $125 without there being a proportionate schedule. So that's all. It's just
once you get up into the bonding amounts, over the $1 million, you are talking more labor intensive. If people have to be bonded, taxation bonds, things like that, that does increase your labor. And these are the cases too that also become contested on highly controversial and complicated matters. So if these cases become contested, there is a small fee to go to the judge level, but they are the cases that will have very high priced lawyers, trusts, and things like that. So they do cost the probate court more money. So.
all right. Thank you very much. I appreciate that. I think we've exhausted that.
Yeah.
Representative Evangelos, did you have a question?
No, I'm confident that Representative Thorne has exhausted it too. So
Great.
I'm happy. I just wanted to point out that Ms. Ayers represents a professional organization, and as amateurs here, we have to rely on the information they've supplied us, and she's a good person and has never misled us before. So I accept their information. It was the product of a study and actual costs. So that's all.
Yeah, and I would just agree with you wholeheartedly, Representative Evangelos, that this was a proposal that was very carefully considered and vetted by the people who did the work and are most familiar with all of the factors that go into the processes on the matters that the fees are charged for. And I agree with you. I think we should respect their judgment, and I'm prepared to do that with my vote. Representative Babbage, you had a question?
Yeah, I just wanted to say that the uneven increases are not necessarily problematic, because perhaps the original schedule deserves some tweaking. So I will vote in favor as well.
Any other discussion on LD 345, which is a very easy bill number to remember? Any other discussion on 345 before we move to a vote? Not seeing any. Ms. Panett, could you please take the vote on the motion ought to pass on LD 345?
I would be more than happy to, Madam Chair. Senator Carney,
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. 11 members voting in the affirmative, 0 members in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. So LD 4345 passes out of committee with an 11 votes in favor. And that closes the work session on 345. And we'll move on to our work session on LD 366, an act regarding emergency guardianship. And Peggy, would you please give us your bill analysis?
Yes, thank you. So LD 366 amends the probate code in the emergency guardianship section. So an emergency guardian is can be appointed in very narrow circumstances. And once again, it's good to have Kathy Ayers in the attendee room because she can give you more details. Currently, the standard for appointing an emergency guardian, the basis for emergency guardianship, the court has to find that A, the appointment of an emergency guardian is likely to prevent substantial harm to the adult's physical health, safety, or welfare. B, no other person appears to have authority and willingness to act in the circumstances. And C, there is reason to believe that a basis for appointment of a guardian under 5-301, that's a regular, long-term guardian, may exist. So it looks like it's an appropriate situation for a guardian to be appointed in a more permanent situation, but there's a reason that it has to happen now, and that's because an emergency guardian is likely to prevent substantial harm to the adult's physical health, safety, or welfare. So what the bill does is tries to define that substantial harm that's currently in the statute. It says substantial harm, and the bill says for purposes of this paragraph only, the delay of discharge of a person in a hospital until the appointment of a guardian constitutes substantial harm. So that is the intention, is to give direction, consistent direction to the probate courts so they can look at a situation where a patient is in a hospital, does not need to be in the hospital, but mainly for the purpose that a guardian hasn't been appointed, that the fact that they're stuck in the hospital in that situation constitutes substantial harm, which gives kind of the court the authority to appoint an emergency guardian in that situation. So you heard testimony on both sides of this. This is part of a much bigger issue, a concern that there are folks that are in the hospital that no longer need the acute care that a hospital provides, and they aren't being moved to appropriate facilities for various reasons. And one of those reasons is sometimes that there's not a guardian, that the person is not considered capable of entering into or making those decisions to move, or there needs to be somebody to make those decisions, or there needs to be somebody to sign some kind of paperwork, and the person can't, that patient can't do it themselves. There are other reasons that patients are stuck in hospitals, not just because they don't have a guardian, but this is targeted to those situations where the only reason that they're not moving out of that acute care situation is because they don't have a guardian and they need somebody to act on their behalf. You had quite a bit of information. You had some anecdotal information about specific cases. There was a working group. The long-term care ombudsman, Brenda Gallant, had convened a working group. This was actually the subject of a study bill a couple of years ago, which kind of got stuck on the study table, so it never got funded. But Brenda Gallant had pulled people together, pulled the interested parties together, and worked through a lot of these issues. And I think they've all agreed that there's a lot more communication going on, and they've tried to resolve some issues. This was a recommendation of some of the people of that working group, but not all of them. And I think you heard a fair amount from people in favor and not in favor of this proposal. After the hearing, you had some questions, and Jeff Austin had put together a memo that I did post in the portal, and I emailed it to you, so I hope you have that. Trying to answer some of the questions that the committee had raised and some of the other people had raised in their testimony. In addition to that, the Department of Health and Human Services provided a one-page memo answering a couple of questions that were raised. So I think that's all I have. If I'm happy to, actually we do have a preliminary fiscal impact statement, is that the Department of Health and Human Services will require general fund appropriations of $9,000 beginning in this coming fiscal year for additional emergency guardianship filings.
Thank you. Senator Keim.
Thank you. Peggy, could you show somehow, maybe screen share or show me where your bill analysis is? Because when I look for a report back at OPLA and what I thought would be your analysis, that isn't. That's the main hospital association. So I'm not finding your bill analysis.
Yeah, it was in an email we received yesterday, was where I accessed it.
Right, it is supposed to
be. So it wasn't uploaded then? Is that right, Peggy?
It should have been in the portal. And I'll just double check, and I can screen share it if it didn't make it in there. Huh.
Madam Chair, if I may.
Yes.
It is in the portal. It's under LD 366 and it's titled Bill Analysis LD 366 at OPLA.
Thanks. So I think part of the problem is we don't have an electronic LD file link for this bill under the Judiciary Committee materials page. So the way you have to find it is by, I think this is how Representative Libby found it, is by going to the LD when it was heard, which was February 24th.
Mm-hmm. So I'm looking at committee meeting materials by LD and I click LD 366 and it's not there. So I have to go to a different location.
Yes, and my apologies that isn't updated. I will email you the link.
Senator Kime, would you like a 10-minute recess to review the analysis?
I would, thank you.
Okay. So committee members, it's 10:40. Let's return at 10:50. And does anybody else need the link to the bill analysis before we take that break? Raise your hand if you'd like it. Representative Babbage would also like it. Peggy, you can.
Oh, okay. I sent it to the whole committee.
Oh, perfect. You're a step ahead of us. Thanks.
Yeah, let me just screen share so you can figure out where you're going to find it.
That's great.
Okay, so share. So hopefully this is the date of the public hearing. So these are the bills that were heard this day of the public hearing. And 366 is down here at the bottom. And you click that down arrow and the bill analysis is right here. So if you click that little blue icon, you'll get to the bill analysis. Did that help? Was that too fast?
I think I can find it now. Thank you.
Okay, my apologies that that link is not posted. For the bills that were heard prior to this portal being open and attached, I don't think those links were added in, but I'll go back and check. And my apologies. So I will stop. So are you taking a break?
Yeah, we'll be back at 10:50 after everybody has a chance to look at that. Thanks a lot, Peggy.
Great, thank you.
All right, you all set? You think? What was your favorite place to visit as a child? Christ.
Good girl. No, we don't need to bark. Come here. Come here. Come here. Stop. Stop, or I'm going to shut the door. Stop. We are okay, you and I. Hi. Good girl. You're fine. We're fine. Relax. Lay down.
Steve, is everybody coming back? I'm sorry, I got pulled away for like 5 minutes and I lost all of you and I had no idea where you were. I'm like trying to find you.
I think we're
So,
here.
sorry, I had a Verizon catastrophe in the other room that I had to solve. The dreaded passwords, and the secret squirrel questions and that stuff.
Hi. Hi.
So did I miss anything other than Peggy's spectacular summary?
No, well, it turned out that there was no link to the electronic LD file that was posted, and I'm actually going through all of them, and I found one other where it's missing. Which meant that Senator Kime didn't have a chance to review the bill analysis. So she is, we decided to take a break and let her do that.
Yeah. Yeah, I printed them all out, and so I tricked the system. If they erased it, no big deal. I've still got them. Just like pulled a tree or two in the process and supported
Yeah, I was
Maine's
gonna
lumber.
say, that's a lot of paper.
Yes, it was.
So for those of you who haven't been on the committee in the past, I really like using different colored papers for different things. So current law is always blue, and I wouldn't put anything else on blue. So if you needed to look at the current law, you could pick up your file and you can find that blue piece of paper. And bill analyses are always on buff. So I miss that a lot.
So do I. I can't find things without it, I have to say.
Right.
I keep trying to find it.
Yeah. Well, just wait till next year. That's all I can say.
I keep trying a new system about every month, and I think, well, now I finally found the system. And then the minute I think that, it's the 25th, and I can't find anything that I put in this perfect system this month.
Peggy, what's the code that you use? Current law, you print on blue?
I do blue.
Okay.
The bill analyses are, I also do, if I copy a case or a rule, something that, is, right, you're not changing it yet. Yeah. That's on blue. The bill analyses I do on buff colored paper. When we actually review language for an amendment, I try to keep that on green. And we even established a system so you didn't have to pull all the LD files when we were just reviewing language. Everybody had a green file folder on their desk, and that's where the copies would go.
Purple is the color for freedom of access.
Freedom of access, yes. We have those review sheets were lavender. And
Clack.
the FLAC report was always on salmon, and we didn't get as many from CLAC or PATLAC, so we kind of experimented with different colors. But
I love to align with things. So
yes, okay.
And then I mess you up and make the weekly schedule different colors every week.
Yes.
You'll have a pink week. Valentine's Day will be pink. St. Patrick's Day will be green.
I like a little variety too. It's a good balance.
We
I have
want
to say, Erin, I miss hearing you say you're from the district that represents downtown Biddeford, because it puts in my head the district, because I'm familiar with downtown Biddeford. So, but it's hard with those of us with multiple reps in the same city.
I like the whole town, but I have a special fondness for my own district, obviously. So,
yeah. It's like Grayson Lookner always talks about representing the airport and area and some other thing out there. I can't remember, Stroudwater maybe. I haven't noticed that Chris Kessler says he represents the transfer station, but I think he does. South Portland. I'll have to tease him about it.
Senator Keim, you'll let me know if you have any questions.
It looks like we're mostly back at this point. So we will, let's see, Peggy took us through the bill analysis and we had a little recess to review it again. Committee members, are there any questions for our analyst? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Peggy, on the first page, you indicate that in the 129th, there was a bill passed by committee, LD 1229, to set up a study committee, but that never happened, presumably because of the adjournment. Am I correct that bill was never signed into law?
You are correct that it was never signed into law, but it was actually passed during the first regular session and it sat on the study table. There's only so much money that the legislature has to fund studies. And so it sat there. And all the people who were included in that study resolved really, the long-term care ombudsman, Brenda Gallant, asked them to meet anyway without this.
Right. It seems as though they did.
They did, and they continue to meet, and they've submitted a couple of interim reports. Those were attached to her testimony about what they've talked about. I know that Senator Bailey participated in a couple of those meetings. I know that Kathy Ayers and Leo Delicata, and I'm not sure if it was Jeff Austin or somebody else from the Maine Hospital Association. All those people were involved in these groups. It was a much bigger group than that.
Oh, okay. So as small as this bill is this the product of that committee?
I would not say it's the product of that committee. They have done some other changes and practices. This is the only piece of legislation that some members of that committee have recommended go forward. Not all members, this is not a consensus piece, but it's certainly a piece that some members of that committee thought would be really helpful in some situations. But there are also members of that committee who disagree with that.
I see. Thank you. Okay.
Yes, it's sort of a product, but it's a product of some members and not all members.
Okay, thanks.
Are there other questions for our analyst committee members? Would anybody like to hear from, go ahead, Senator Keim.
So Peggy, a part of, and I'm remembering discussing this bill before and wanting to do something about the problem, the issue of people being left, which I know is a problem. What I'm remembering and reading in testimony is the piece of changing substantial harm to include being left in a hospital. When I think substantial harm, can you just go over with me what substantial harm would normally be considered in law, so that as we consider adding this to that definition, what I think one of the issues that has merit is that we are sort of lessening that meaning. So can you help me understand what some other substantial harm would be, what the meaning, the legal term would be, or other situations that would be pertaining to? Is it only civil liberties, or what other things?
No, well, it's anything substantial harm to the adult's physical health, safety, or welfare. And remember that another piece of this emergency guardianship is it looks like it would be appropriate to appoint a permanent guardian in this situation, but we really just can't wait for that whole process to go through. So it's not just somebody who might need a guardian to help them go through their, make decisions on a daily basis, or not even that. This would be an emergency situation. So they're not eating. They're putting themselves in a dangerous situation. Maybe they're they're just walking out the door of their house all the time. It's substantial harm. The court right now, the probate court, the probate judges look at the situations. They have to, whoever is putting forward the petition, which is kind of another question you might want to look at. Whoever is petitioning for the emergency guardianship has to identify what's happening and why it creates, it would create substantial harm if an emergency guardian weren't appointed. So it's usually a potentially dire situation, I think. Maybe it doesn't have to be crisis level, but pretty bad situation, imminent, in order to do this on an emergency basis, because limited notice to the person, limited notice to all the people who are involved in that person's family, and the emergency guardian can be appointed without the person being there, without the respondent being there and being aware of what's going on. So it really needs to be a very difficult situation for the respondent, the patient, the person who this guardianship is about.
And so in this situation, the petitioner would or could likely be the hospital, but then whatever, is that correct? And then whatever imminent harm they're seeing, the probate judge, I assume probate judge, would still be making the decision on whether or not the alleged harm equals an emergency guardianship being placed over them, right?
Right. So yes, that it's still the judge making that decision, looking at all the information that's provided. It would not be the hospital that would be petitioning. I don't think normally a hospital or a long-term care facility or any of these facilities can actually petition to be a guardian, because that's a conflict of interest. So it would have to be somebody else. And in most situations, when you're dealing with somebody in this situation, it really means there's a family member who is not, there's no family member available to take over this role. So you're relying on the state and DHHS, Adult Protective Services, APS. The hospitals, I think, are relying mostly on APS to step in and file an emergency guardianship petition. So you've got two steps there. Adult Protective Services will be filing the petition for emergency guardianship. So you have to get DHHS to recognize that it's a situation where it's necessary to prevent substantial harm. And then you also have to convince the probate court that appointing an emergency guardian in this kind of truncated fashion is the appropriate thing to do.
Right. Okay. And I asked that question wrong. What I meant is who initiates this. So it would be the hospital, or they would initiate the process and reach out saying, hey, there's a problem here.
I think that's true.
Okay.
And I'm not sure if there's anybody from DHHS, from Adult Protective Services, that could speak to that. But that's my understanding, is that these don't come out of the blue. There are conversations happening about this patient because the patient's been in the hospital, not needing acute care, but taking up an acute care bed. And so the people in the hospital, the providers, are talking with whoever they need to talk to try to change that situation.
Okay, thank you. I have one further question of maybe someone who's waiting to be part of the panel that might be able to answer. But in the bill analysis, one opponent said the reality is that an individual is rarely, if ever, stuck in the hospital due to emergency guardianship provision not including this definition of being too long in the hospital. And so I wonder if anyone can answer if there is actually definitive data around people who are stuck in the hospital and whether or not it's because they don't have a guardian, or rather there's other issues as is being suggested here.
Yeah,
I don't know if it's all anecdotal, if we actually have data.
Right. If I could point out, Erin Salvo from Adult Protective Services is in the attendee room, and she has her hand raised. If she can answer any of that, maybe.
Yeah, let's pull her in. And Peggy, I just wanted to ask you a question, kind of following up on what Senator Keim was asking. In the proposed bill, do you interpret the proposed bill as saying that delay of discharge of a patient in a hospital is always substantial harm, such that it would sort of trump other evidence that maybe would lean against that being substantial harm?
I think it's worded that way. I don't know if it's intended to be worded that way, but it says this is substantial harm. And so the probate judge can move on to the next step, I believe. That, okay, check off A, because the statute says delay of discharge until the appointment of a guardian is substantial harm. A is checked off, and then you go on to B and C.
Yeah, that's my concern too, is that it's always substantial harm. Ms. Salvo has joined us. And Ms. Salvo, would you like Senator Keim to repeat her question, or are you able to answer it right now?
I think I'm able to answer it. And I think there were two pieces. In terms of the substantial harm definition, or the circumstances when we are petitioning for public guardianship on an emergency basis, typically we have done some analysis of recent cases. So looking at our data from for the calendar year 2020, about 25% of our cases were an emergency guardianship as opposed to a standard public guardianship petition. And of those, 7 of the individuals were in a hospital. So the kind of the broad categories of substantial harm we're saying are, we need to separate an individual from a perpetrator of abuse or neglect who has immediate access to the individual, a caregiver or a current private guardian, potentially. Also an individual who is living home alone who's had cognitive decline, who may be wandering, especially wintertime, those types of concerns. And in particular for some of the clients who are in the hospital, that can include the need for immediate medical care, authorizations around surgery, something like that. And in some instances, also placement authority, which for us is typically if someone requires a locked dementia unit, which an individual must have a surrogate decision maker in place or a guardian in place for a locked dementia unit to accept a new resident. That's different than your typical nursing facility where a guardian is not actually required for admission. So those are what we are generally seeing for our emergency guardianship petitions currently. In terms of the quote you pulled from the public hearing around an individual rarely being stuck due to this definition, that really points to the fact that we do pursue emergency guardianships, as I mentioned, for individuals who are stuck in hospitals. And then we continue to see that even where someone is under guardianship, they remain in the hospital beyond that time. So it's not that having an emergency guardianship in place is kind of that golden ticket out of the hospital. It's much more common that there are many complex issues for those individual patients where we see that they remain in hospital. So we have been more recently tracking some of that data. And we have currently 12 individuals who are subject to public guardianship who are long stay patients in hospitals around the state. And they're averaging right around 155 days in the hospital due to various issues. So again, some of that can be the limited availability of locked dementia units, particular combinations of challenges. So if someone has behavioral health needs and very high physical needs, those are placements that can be hard to come by, or willing to find a facility that feels capable of meeting that individual's needs. Also, someone has a sex offender registry status, that can make it very difficult to find a nursing facility that's willing to meet someone's needs. So we see that some of it has a little bit more to do with resource development and availability of placements, or quite a bit of it has more to do with that issue than it is truly the emergency guardianship piece. And so when we kind of get into making that assessment for individuals in a hospital, we do pursue emergency guardianship, but we are kind of adding that as a factor in combination with other things like the need to finalize main care application process or other pieces. Certainly if someone needs a locked dementia unit, we're going to pursue emergency guardianship because we wouldn't be able to help facilitate that placement unless we have that guardianship authority.
Did you have any follow-up questions, Senator Kime?
No, I don't think so at this time. Thanks.
Okay. Representative Reckitt?
I'm trying to figure out why, if you're already doing emergency guardianships for these folks, why we need to have a different, why this bill is necessary. That's my question. I mean, it sounds like you're proceeding on without it to the same end. So why is this required? Maybe that's not an answer you can make. Maybe it's a hospital-based question. I don't know if anybody's in the attendees that's from representing the hospitals, but I'm just confused now. I was doing great until I got to the place where you're doing good stuff and getting people out and doing all that stuff. But then I'm going, well, why do we need this if APS is already able to initiate that process? I don't know if it's an answer for you or if it's an answer for somebody else, but so I would sort of like to hear from the, I mean, I sense that the push on this is coming from the hospital end. So I'm sort of curious as to what their take on this particular narrow question of why we need this if this process is going as we thought it should.
Thank you, Representative Reckitt. I think what we can do is we can have Ms. Salvo answer it, and then we can also bring into the panel Ms. Harvey McPherson to answer it. So Ms. Salva, why don't you address that question, and I'll bring Ms. Harvey McPherson in.
I can mention that DHHS, I participated on the task force that was discussed a little bit earlier, and DHHS was not part of the cohort within that group that was in favor of this statutory language. I think that's just differences of opinion on what the probate court's authority should be. There's been discussion in the past where some probate court judges will have said essentially under no circumstances is someone in a hospital subject to substantial harm because they are safe, they're getting fed and have a bed in a hospital, and there are differences of opinion around that, which is why we try to make sure when someone is in the hospital, we're providing that additional evidence to support why it needs to be heard as an emergency.
Thank you.
Welcome to the panel, Ms. Harvey McPherson. Would you also like to answer that question?
Yes, I would. And I want to make sure, can you hear me okay?
Yes.
Great. I've had trouble with my audio this week, so I'm very cautious. So thank you for the opportunity to share some information with you today. I'll talk about emergency guardianship, and then I'll talk a little bit about the patients who do need guardians for purposes of discharge.
Actually, before you begin your answer, because we've had a really pretty robust public hearing on this. And I think at this point we're trying to kind of narrow in more on the specific question. So if you could focus particularly on Representative Reckitt's question, that would be helpful.
Yep. And the question really was answered in Erin's testimony on behalf of Adult Protective Services, and she shared that information just now. There is variation in probate court interpretation of a patient stuck in a hospital needing a guardian for purposes of discharge, and does that constitute substantial harm? There are courts that will recognize that and proceed with that for purposes of emergency guardianship, and there are courts that do not. So what this bill does, in part, is provide consistency. So the probate court has clear direction from you as policymakers that when a patient is in a hospital clinically qualified for discharge and they cannot be discharged for purposes of guardianship that constitutes substantial harm, that begins a process for an emergency guardian, with the full process for a permanent guardian remains unchanged. That permanent process will move forward as it does now.
Thank you.
Yeah, thank you. And can I just ask you the question that I'd spoken with our analyst about? To your understanding, does this mean that anytime there is a delay in discharge, that automatically constitutes the standard necessary? Let me just read it. That automatically constitutes substantial harm?
So the patient must be clinically qualified for discharge, and the only barrier to discharge is the need of a guardian, that the patient lacks capacity. And when those two criteria are met, then yes, that would constitute substantial harm.
Thank you. Let's see. Representative Libby, go ahead.
Thank you, Madam Chair. We've heard a lot about substantial harm and how that is defined, but we haven't heard a lot about what that looks like in practical terms. Mm-hmm. And so I would like to hear more about that. In my tenure working in the ICU as a nurse, I have frequently seen cases where folks would not be discharged either from the ICU or from the hospital. And while main hospitals are excellent at providing acute care, they're not set up to rehab patients who have moved beyond what they need in the hospital.
Mhm.
So can you speak to that and how an appropriate level of care in a nursing home or a rehab facility actually benefits a patient versus the hospital setting?
Sure, thank you for that opportunity. So the scenario is a patient presents to the hospital. Very often they present through the emergency room. They have a medical or surgical event, and they are treated and medically stable. We have addressed their clinical needs, but yet they need support with activities of daily living. They are unable to live at home with home care supports. Generally, as a rule, they need 24-hour nursing care to continue to reside safely in a community-based environment. At that juncture, what the hospital has done, and they've done very well, they've cured or significantly improved the medical condition. But the patient now is in a room without social supports, without stimulation and activities of daily living. They're limited in terms of their mobility. It's not really safe to have patients wandering around the hospital. So they're isolated in a very small room, very often confined to their bed, except for limited instances when they're assisted with a support person to ambulate a little bit. Conversely, a nursing home becomes their home environment. They have 24-hour nursing care, but they have the ability to engage in activities designed to stimulate them mentally, designed to stimulate them physically. They are supported with staff with free mobility in the facility. They are engaged socially with community groups and family members and others that enrich their lives in that environment. And they thrive. What we see in the hospital environment, a mental health component becomes a significant challenge as these patients deteriorate mentally. No one wants to live in a hospital against their will. And by the time they're there for 4 to 6 months, those clinical gains that we made that were so important when they were first hospitalized, in some ways become eroded because of the emotional impact and the physical deterioration impact of just simply being largely confined to a room.
Thank you very much. That is the exact clinical picture I have seen many times from patients malingering in a hospital. Thank you.
Representative Sheehan?
Thanks, Madam Chair. I heard some compelling testimony during the public hearing that the most substantial barrier to discharge is actually a lack of service providers to provide the kind of substantive care that you describe. And I'm really concerned that the answer to this problem is not so much making it easier to assign a guardian, thereby potentially removing some constitutional and civil rights of the patient. I in my notes, I heard Ms. Ayers express a concern that the whole move might not be constitutional. So I would love to hear either of your thoughts on the potential constitutional problems of easing assignment of guardianship in this way.
Aaron may be better on the constitutional piece. I do want to set the stage of why patients are stuck in hospitals. And it's a big issue. And we're working on this. And you'll see bills coming through on the need for bariatric beds in nursing facilities. You'll see bills coming through on the need for behavioral health, residential treatment facilities. There's a lot of reasons why patients are stuck in hospitals. But when you look at the totality of who is stuck, The highest volume of patients are those in need of a guardian. And there is a subset of those patients that are difficult to place. But what we find is the number one reason patients are stuck in our hospitals is they need a guardian. The vast majority of them, when the guardianship issue is resolved, we've taken care of the main care issue, then it's very easy to place them. And we will still have a cohort of patients that will still be stuck in the hospital for a whole different reason. And some of those require policy solutions, and we're working on those too.
Thank you, Ms. McPherson. Ms. Salvo, did you want to weigh in on that, please?
Sure. I think the constitutionality question really is centered around the due process that comes with the full guardianship petition process versus the emergency. So when an emergency is being requested, there's not the same sort of structure to appoint an attorney, and sometimes that decision, generally that decision is being made at an ex parte hearing. The individual may not even know that a guardianship is being established. I think some of the concerns that we raised in the testimony at the public hearing was around that piece. And does someone saying, no, I don't want to go to the placement that you're recommending I go to, constitute a barrier to discharge that might be a basis for overriding that decision by establishing an emergency guardianship, things like that, if the person has questionable capacity. So those are some of the concerns. I think too, Ms. Harvey McPherson and I are in total agreement that trying to get someone into the right level of care is the most important piece. What we find around the substantial harm element is that when we pursue emergency guardianship for someone in a hospital, and as a basis for that emergency, we're saying this person shouldn't be in the hospital. If we then go back to court 6 months later on a regular petition and that person's still sitting in the hospital due to the other issues at hand, we hear judges, what was the emergency? Where's the substantial harm? You said guardianship was going to get this person out of this circumstance, and it clearly has not due to all the other issues that we're seeing. So I think I really am not sure there are strong examples of cases where the only issue is get a guardianship established that we're not already pursuing.
I was muted. Committee members, are there any other questions for Ms. Salvo or Ms. Harvey McPherson? Is there any other information committee members would like before we move on to a vote? Is there any discussion among committee members related to this bill? Representative Babbage first, and then Representative Libby, and Ms. Salvo and Ms. Harvey McPherson, I'm going to move you back to attendee status. We really, really appreciate the information that you've provided today. And thank you for helping us with our decision-making process.
Thank you.
Representative Babbage, did you have a question?
I had a comment because I am a co-sponsor, and I appreciated Ms. Harvey McPherson's explanation of the problem. It's exactly why I signed on. But in the deliberation of the bill and so forth, I've become I guess attentive to I think what turns out to be an erosion of the judge's discretion on the issue if we define substantial harm as this qualifying as substantial harm. So I just wanted to explain, because I'm a co-sponsor and sympathetic to the problem, I have reviewed the evidence, and I think I'm going to vote not to pass on this bill. So thank you.
Thank you for
And
sharing.
ma'am, I have been listening attentively, but the reason you're not seeing me is because it's being done from above. The host or someone is keeping my visual away, and it may be for the benefit of the committee. I'm not sure.
No, I don't know. Because I am trying to activate your camera on my end, and I can't do it either. Oh, yay. You're back. We're so happy to see you. All right.
Thank you, ma'am.
Thank you for your comments. Representative Libby, you may proceed.
Thank you, Madam Chair. Nice to see you, Representative Babbage.
Thank you.
I strongly support this bill. I think we can see substantial differences sometimes between what you see on paper and what actually happens in practicality. And as a nurse practicing in the ICU here in Maine for 15 years, many times I have seen patients malinger in the hospital far longer than they should. And it's tragic when you have you fixed someone's medical needs and then you see them start taking steps backwards physically and mentally, especially if they already have deficits in that area while they wait for a placement. No, this doesn't mean that someone will immediately get a placement in a nursing home, but if we can help remove one hurdle to get someone to the appropriate place of care, and that's worth doing. It's important to these folks' mental health and physical health to get them to a place that is appropriate for them. And so I very strongly support this bill.
Thank you, Representative Libby. Other Representative Reckitt? Representative Reckitt, did you wish to speak?
Is this a moment when I could make a motion, or is there one on the floor?
There is not a motion on the floor.
Well, I'd like to make a motion ought to pass.
Can you activate your camera, please?
Sure, I can. Yeah.
Thank you. Do we have a motion to pass? I'm
Yes.
sorry. Can you restate your motion, please?
Yes, my motion is ought to pass.
Is there a second? Representative Evangelos is a second. Any discussion of the motion? No. Okay, Peggy, would you like to, you raised your hand?
I just want to clarify that there is a fiscal note. A fiscal note will be required. So you may say ought to pass without changes to the language, but it will need to be ought to pass as amended to include the fiscal note.
Thank you.
Which actually might include an appropriation.
And thank you, Peggy. Representative Sheehan?
I just wanted to echo Representative Babbage's concerns and some of the testimony that we heard. I take this problem very seriously, and I just don't think that easing the process of assigning an emergency guardian is the answer to getting these folks the appropriate care. So I will vote against the current motion.
Thank you, Representative Sheehan. I'd also just like to contribute my thoughts on this. I'm really concerned that the language that's before us takes away the discretion of the judge in every instance, and that I think is very concerning, particularly when we're talking about depriving somebody on an urgent basis with limited notice of their rights to self-determination. So I'll also be voting against the motion. pausing to see if anyone else wishes to raise their hand and contribute to the conversation before we move to a vote. Representative Moriarty?
Thank you, Madam Chair. Not much of a contribution, I'm afraid. This is a very complex and difficult topic for me. But bottom line is for me is that I've looked at the testimony we received at the public hearing, and I really appreciated Representative Libby's comments, because I like to turn to those, regardless of what the issue is, who have hands-on experience in the particular situation presented by a bill, and I'm impressed by her assessment of that experience, and so I'm going to vote in favor of the motion.
Anyone else wish to speak to the bill before we move to a vote? Not seeing any hands. Is the committee ready for the vote? Yes, looks like it. Soupy, you can call the roll.
Thank you, Madam Chair. Senator Carney.
And this is the motion ought to pass as amended. No.
Senator Carney votes no. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckett.
Yeah. Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. I have 6 members voting in the affirmative, 5 members voting in the negative, 3 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. Just for members of the public who may not be aware, committee members always have, well, with a few exceptions, but committee members do have, who are absent, have 48 hours to register their votes. And that's the case with this legislation as well. Just wanted people to be aware that the numbers may change over time. And let's see, that concludes the work session on LD 366. And we will move into the next matter. This is opening the work session on LD 480. And let's see, Peggy, can you present us with the bill analysis? And I also just wanted to let committee members know that we'll be taking a break, a lunch break starting around noon. And so we'll start on LD 480 and see how far we get. Thanks, Peggy.
Thank you. So this is LD 480 is an act to establish a presumption of entitlement to counsel for a person who is the subject of an adult guardianship, conservatorship, or other protective arrangement proceeding. So we're still in the probate code. And in each of those situations where a guardian there's a petition to appoint a guardian, there's a petition to appoint a conservator, or there's a petition to create some other protective arrangement that's not quite as restrictive as a guardianship or a conservatorship. There is an opportunity for an attorney to be appointed. And the current law in each of these situations says the court shall appoint an attorney to represent the respondent if A, it's requested by the respondent, B, it's recommended by the visitor. The visitor is somebody that the probate court sends out to talk to the persons who is the subject of the petition and examine their circumstances and figure out what their wants and their interests are. C, the court determines that the respondent needs representation. So the court identifies that the person really needs to be represented by an attorney. Or it comes to the court's attention that the respondent wishes to contest any aspect of the proceeding or to seek any limitation on the proposed guardian's powers. So, I mean, that could happen by the respondent writing a letter to the judge. We actually heard a probate judge say that somebody who was in this process wrote and said, I'm concerned about this going forward, or I want to make sure that I still have the right to engage in certain activities, that the guardian is not given the authority to cut off my participation in these activities. And in those situations, the current law says that the probate judge has to appoint a lawyer. So if none of those situations, none of those fact patterns are there, the probate judge is not required to appoint an attorney and does not appoint an attorney. And indeed, you've heard some of the testimony that a lot of cases, this is a family member trying to take care of somebody, and the probate judge does not think that an attorney needs to be appointed, so the probate judge will not appoint an attorney in those situations. That's current law. The bill says we're going to create a presumption that an attorney should be appointed. And an attorney does not need to be appointed when the court finds by clear and convincing evidence that the respondent or the adult subject to the guardianship knowingly and voluntarily refuses the representation and does not wish to contest any aspect of the proceeding or seek any limitation on the powers of the guardian or the conservator. So it's kind of it's kind of reversing where you start. What's the default? The default in the current law is you appoint an attorney if any of these fact patterns exist, and under the bill, it's appoint an attorney unless the court finds by clear and convincing evidence that the person doesn't need an attorney and doesn't want an attorney. And so that's where you are. A reminder that the probate courts, when they appoint an attorney, that money comes out of the county account. It's not MCILS. It's not the Commission on Indigent Legal Services, although there is some talk about trying to make that the go-to place for any appointed attorneys. In addition, this bill has come up before, and the testimony before was that the probate judges are pretty confident that they've been appointing attorneys when they've been when it's been necessary, and that one way to look at that is there might not be more attorneys or a significant number more of attorneys appointed under the bill if the probate judges have been able to recognize that when attorneys are needed, when somebody's interests need to be represented by a legal representative. So I don't have a fiscal note for this. What I have included in the bill analysis, one of the questions that came up was, here, let me just go through some of the questions. What part of the probate code provides that payment comes from the estate of the respondent? So if the adult who is the subject of the petition, if they have an estate and can afford to pay the attorney, that's where that gets paid from, not the county. That's in Title 18C, Section 5119. Unless the court has made a finding that the respondent is indigent and has appointed an attorney for the respondent on that basis, an attorney for a respondent in a proceeding under this act is entitled to reasonable compensation and reimbursement of reasonable expenses from the property of the respondent. So if the person's indigent, that's when the county pays for it. There was a question about what does a judge look for in determining competence. I included the definition of incapacitated person, which is in the definitions that covers all of the probate code. Incapacitated person means an individual who, for reasons other than being a minor, is unable to receive, I'm sorry.
Can I interrupt you just because I think it might be actually helpful for us to see that definition. Do you mind screen sharing the bill analysis? Thank you.
My computer likes to rest a little bit. Okay.
That's great. Thank you.
So, is that the end? Okay, so here's Title 5, I'm sorry, Article 5, Section 119. This is the definition of incapacitated person. So I think this is basically what a probate court judge will look at to determine if whether the person is competent. There's also, you asked how many adult guardianships each year. Kathy Ayers, we've been working on this for a few years, and she pulled together all the statistics from 2018. I'm not sure that she does this every year, but she did it for us in 2019. So she had the numbers for each county. She contacted each county and got adult guardianships, adult conservatorships, joint adult conservatorships. And before the new probate code went into effect, we had something called single transaction authority, which is kind of the precursor to what we have for other protective arrangements. And so these are the number of cases across the state in 2018. Things may have changed drastically, but that was in 2018. I don't know that it's tracked how many cases have gone forward with or without counsel. And then one of the questions was, why did the Uniform Law Commissioners not require appointment of attorneys in all cases? So I went back and looked at the most recent version of this uniform law, and I believe it came out in 2018. Is that right? Anyway, the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, which we've adopted as part of our probate code in it's parts of Article 5. In the way, I think that Molly Liddell, when we were talking about the Trust Decanting Act, said the Uniform Law Commissioners say, here are two ways to go forward on this issue. And that's what they said on this about appointing an attorney. Alternative A was what we've adopted in our probate code. The court shall appoint an attorney if these situations exist. That's alternative A. The Uniform Law Commissioners also said, well, there's another alternative to that. That's alternative B. And that's, unless the respondent is already represented by an attorney, the court shall appoint an attorney. So that is actually a stronger version than what is provided in this bill. PATLAC led the recodification and revision of the probate code. They retained alternative A because that was consistent with what we had in our law leading up to that we've had in Title 18A all along. So rather than disrupting that, Patlack went ahead with alternative A. And there was discussion a few years ago when we were working on the probate code, and they decided that that would be a separate bill. It was a separate bill in the last session, and I believe, I'm trying to remember what exactly happened to that bill, but it did not get enacted, and I think it was because it was the legislature adjourned. So here's the comment from the Uniform Law Commissioners. So they provided alternative A and B. And I'm just gonna scroll through. In light of it, states may wish instead to adopt alternative B, which provides for mandatory appointment of counsel. So that was supported by the ABA, whereas alternative A is supported by the Probate Courts Association. So you're not the only people who have struggled with this question, obviously. But I just wanted you to know that it's not that the Uniform Law Commissioners said you should always go this one direction with this provision in the statute. And I think that's all I have. I think I've answered the questions that were raised.
Committee members, are there any questions for Peggy while we've still got the screen sharing going on? Representative Babbage?
Yeah, thank you, Madam Chair. No, Peggy, I just wanted to ask for the distinction between option A in the uniform and current law.
There's not much.
Okay.
There's not much difference. I think we might have one more provision, which is I think the extra provision is that the judge is aware that the court determines the respondent needs representation. We have one more, which is it comes to the court's attention that the respondent wishes to contest any aspect of the proceeding or to seek any limitation on the proposed guardian's powers. Which I think we had that in our statute before we adopted the latest Uniform Probate Code.
What was it in the 129th that you said was not enacted?
There was a bill, I want to say it was LD 531, that it actually, the original form of it was much more like alternative B. And the committee, you carried it over because you were trying to deal with all the appointed attorney bills at the same time. You carried it over, and then you ended up going with this presumption. So it's a presumption. Here's your first step. You appoint an attorney, but that presumption can be rebutted if the respondent knowingly and voluntarily refuses such representation. I mean, you're asking somebody who is the subject of a guardianship petition to knowingly and voluntarily waive representation. So that's kind of might be a little bit of a difficult situation there. But that's where it starts. It starts out that, yes, we're going to appoint an attorney, and then we're going to say, we don't have to appoint an attorney in these circumstances.
Thank you.
Representative Reckitt?
Oh, somehow I've lost my question in the ether, so I take it back, whatever it was.
All right, Representative Moriarty?
Thank you, Madam Chair. Is it possible to beam up Kathleen Ayers from the attendee room for a question?
Absolutely. I can find her. I am up. Here she comes. Welcome back, Ms. Ayers.
Thanks, I think.
How does it feel to have been beamed?
Yeah. Pretty good.
Ms. Ayers, I know that you testified in opposition to the bill, and of according to some of the brief notes that I took, one concern of yours was the clear and convincing evidence standard to rebut the presumption and the possible impact that might have upon the available pool of attorneys, which is limited anyway, to serve in this capacity. If the rebuttal standard were lowered to a mere presumption of a mere preponderance of the evidence, would that satisfy your concerns?
It would help. I think it would help. Let me just say, because it's not always DHS. It's often families. And my objection was because of what a family would have to put on to rebut this, and the process. Another process in front of all the process that also, and that's the thing. We're talking about trying to hurry things, get things through, and we're also talking about the amount of work that we have in these cases, and we're putting another layer of process in front of it when we feel that we're already using our pool of attorneys. And it's not fair to some of these counties who do not have the attorneys. Washington County, Aroostook County, I think that the registrars really wanted me to get the point home that it's not easy to find an attorney to act on an emergency basis and then be ready for a trial in 14 days, which is what has to happen in an emergency. The next process is within 14 days that they have to prove again that this emergency is needed. So the pool of attorneys is a big, big problem. It's not because I don't believe everyone should have representation. I don't think that the number is available in the rural counties. It's just not.
Okay. That helps. Thank you for your answer.
Yeah. Senator Keim?
Thank you. Ms. Ayers, thank you for being here. I do remember this bill really well last session, and it was my recollection that the probate judges were more involved, but then as I think back, it might be because we went and had a meeting with them personally and this bill was brought up. So that might be why I'm remembering more involvement. But what stuck in my mind is that there wasn't a problem here to be solved. I heard from the probate judges and as well from you that we're not, that the judges are very cognizant of who's in front of them and their needs, and they're very careful about making sure if there's any question at all that representation is required. So I wonder if you could just speak to that as well, and if you're aware of a problem.
I'm not aware of a problem, and I think it's because we have a visitor that goes out and does an interview, and even in COVID times, we've been able to do that. And it's also required that the person be at the hearing, either electronically or in person. So even until the day of the final hearing, that person has a chance to say, we do mechanical devices, we do interpreters. They have a chance to say right up until the last moment, and even after the guardianship goes through, they can always come back. So I think the new protections in the new code are really enough, and I don't think that some entities who have been fighting for this have given the new code a chance to show that we are upping our money for attorneys. We want to have attorneys for people, and we have all those double checks. We have the families and their affidavits. We have the visitors that go in, and we have them in person at the hearings. So by video or electronic means, if possible.
Thank you.
Committee members, are there any additional questions for Ms. Ayers? I know that I had mentioned earlier that we would take a break at noon, and I just kind of want to check in with committee members. I don't know if committee members feel that we're ready to move on to a vote. We have not discussed this bill among ourselves. Would we like to take a recess now and return for discussion and a vote? Senator Kime?
I'm ready for a vote, but I also have worked this bill already once before and had, a lot of discussion on it, but I would move ought not to pass.
Is there a second?
Second.
Seconded by Representative Libby actually had her hand up first. Representative Reckitt, I think she beat you to it. Okay, there is a motion by Senator Kime and a second by Senator Libby. Committee members, is there discussion? Representative Sheehan?
Thanks, Madam Chair. The quote that I wrote down during the public hearing, that imposition of guardianship based on incapacity is the most severe restriction the law can place on a person short of imprisonment, is just echoing in my ears. So this is a huge concern of mine. And I will vote no on the current motion, but I would love to look for an amendment that could answer some of my serious concerns about civil liberties.
Madam Chair?
Yes, go ahead, Representative Babbage.
No, I'm on. I'm sorry. Yes, thank you. I know you've got to go, and I would actually like to revisit something, and so I wondered if we could recess for lunch and have a caucus 5 minutes before our reconvene time, just to check in, and then have a vote at that time. This is one of the bills that I was unsure about going into today, and I'd like that time if I could, since my folder was not with me first thing this morning.
Is that acceptable to you, Senator Kime? It's your motion.
Yeah, absolutely. I only made it to see if everyone else was ready. That's fine with me.
Sure.
Okay, so
Well, that's appropriate.
Representative Evangelos?
Thank you, Madam Chair. It's not about the lunch break. I'm studying the bill, and I'm thinking over what Representative Libby said, and it's got me to thinking. So I was kind of running under the assumption that the providing of legal counsel was to protect the person's civil liberties and civil rights. Now I'm confused. So if somebody can come back after break and answer that one for me. I just thought that the providing of legal representation was there to protect this individual's rights. And if I've got that wrong, I'll stand corrected. I want to have somebody mull that over for me and straighten my mind around it, because I'm not sure. Thank you.
I would, why don't you re-raise that question, because we'll have time for discussion on the motion when we return, and you can re-raise that, Representative Evangelos. Thanks for bringing it up. Representative Babbage? Oh, okay. All right, so we will recess until 1 o'clock. Actually, let's do 5 minutes after 1, please. And just remember, the live stream continues, so please deactivate your audio and video. See you all at 1:05.
Good afternoon, Representative Thorne. Soupy was looking for Sophie.
Looking for Sophie. Yep, she's there. He's looking. Oh, he's muted. I can ask him to unmute. Oh, there she is again. Oh, she's so cute. What a sweetheart.
Yeah,
I
she
like the way
knows
she-
it. Too.
We were
I
asking
like the way she seems to know where the camera is.
Oh, trust me, we do a lot of FaceTiming. She knows your name.
Very good.
That took a long time, huh?
These are my mutts. Can you see them? Oh, maybe not.
Kind of. One looks like a sheepdog.
They're two Shih Tzus.
Oh, Shih Tzus.
Yeah, they're much smaller than you're thinking. I can see why you would interpret that picture that way.
Just a lot of fur. Now, where's Peggy's? Let's see Pippa and Rosie. No pictures? Well, all a little crazy about our babies.
So just so you know, we have motion detectors on our lights, and sitting at my desk is not enough motion. So exactly. If you see me doing that, I'm turning the light back on.
I'm sure that would have been funnier if my mic was on. I said, if you see me doing that, I'm being held up.
Oh,
Call someone.
okay.
This must be the legislative time I've heard so much about.
Indeed, Representative Thorne.
So I never did get a chance to see where I am on the horseshoe.
Oh. Yes. If you were here today, you were going to sit in Representative Poirier's seat, I believe.
Oh, well. I'm pretty comfortable on the end. Virtually, that is. I jumped on the Climate Council Zoom while we were on break. Saw a lot of familiar faces from both Marine Resources and here on Judiciary. So is next week's work session schedule committee out yet?
Yes, I did. Gosh, are you getting email from me when I send it to the Judiciary Committee? Did you just get one?
I just got a
I'd have-
calendar.
I'd have to look.
Okay. Yes, so we can't meet Tuesday and Wednesday, and we had full days planned, so we'll reschedule those.
Mhm.
We are meeting Thursday at 10 for a public hearing, and then 1 o'clock for work session.
Hey, Peggy, they blocked the 31st out now too?
Yes.
Because
We
they
were
only,
told to cancel both days,
just in case.
just in case.
So what happens if we get our business done on the 30th? What are they gonna do?
I guess you have the 31st off. I don't know.
Well, we
I
let 'em-
also,
Go
I
ahead.
don't know how fast they can convene in special session. I mean, I think they can do it very quickly if they're prepared.
You mean they would go into a special session on the 31st?
I think that if it took them 2 days to do the budget, that they could then go into, they'd adjourn and then they'd go into special session for the next day.
Huh.
Excuse me, my phone is ringing.
Hey, Rena,
Yes.
what's that, caucus therapy?
I'm sewing. Do
I know you are. Keep waiting, right?
I'm getting ready to go fishing.
I know. That's why I was going to tell Peggy, if they're going to give us a day off, April 1st would have helped. Where are you going?
I'm not sure yet. I might just go local or I might go down to Machias.
You go, is this Elbers?
Yeah.
Getting your net ready?
So, yeah, can you see it?
Yeah.
There's a tear on the, oh, it's not coming out.
Yeah.
Rim,
Yeah.
there's a tear on the rim.
Yep. And those things can squeeze through some small spaces, that's for sure.
Yeah, last year, I've been fishing for quite a while, but last year, I was late with my application, and then I thought, oh, that's fine. We'll be in Augusta anyway. I won't fish. And then no sooner we get we get dismissed, for the session. So it was a missed opportunity last session.
Yeah. You didn't miss the whole season, did you?
I did.
Oh, that's terrible.
I did. I think we were down in Augusta and I missed the application deadline date.
Yeah.
And so I try to make myself feel better by saying, oh, we'll be busy. We'll be down in Augusta. And then we ended up adjourning.
Yeah.
But I was out 2 nights already, just kind of
Scouting around. Yeah. You seen any?
Yeah, surprisingly.
Just don't tell your secret spots if everyone's listening.
I think it's because it's so warm out.
Oh, yeah, they're moving earlier, aren't they?
Much earlier, yeah. Yeah, so I thought I'd take a few minutes to mend.
Yeah.
Yeah. I don't know if I can ask this out of session, but Representative Evangelos mentioned something that you had said. And I'm not sure what that was.
Oh, I
but,
think it was Aaron that said it, I'm pretty sure.
Oh, it wasn't Representative Libby?
I don't think so. Was it Laurel? Was it you? I thought it was Aaron.
I don't know. You said my name, but if it was me, it would have been when we first had a public hearing on this.
Yeah, then I was mistaken. I was talking about the comment that Aaron made about whether the person was surrendering some constitutional rights regarding the appointment of a legal counsel. So I'm sorry if I mentioned your name. I meant.
Oh, because I was going to ask Representative Libby to remind me what that was, because I went back on YouTube and I was scrolling back thinking, what did I miss?
Where is she?
I went scrolling back and I couldn't find it.
No,
thank you.
Did you mean
Aaron? She raised the point of whether we were violating someone's constitutional rights. That made me confused about what we were actually doing here.
So Representative Sheenan?
Yeah, she
okay.
I must have had brain referenced the wrong rep. Sorry about that.
No worries, Steph.
Thank you.
Hi, everyone. I'm so sorry for the delay. I appreciate your patience. And excuse me, Representative Evangelos, I think you were going to start us off with your question that we had just prior to the break.
Which apparently I flubbed up on it because a couple of the representatives asked me about it, and I was referencing an idea expressed by Representative Sheehan, not Representative Libby. And so that created some confusion. But the second thing I wanted to ask you is, I have to leave at 4 o'clock today. So if we're running late on all of these, can we spend 5 minutes before I leave on the little bit of a budget discussion? I had some questions around that.
Oh, yeah, that's right.
You indicated the other day that we
Yeah.
would do it at the end, but
I know that Representative Harnett also wanted to participate and he's not able to be with us today.
well, I mean, Tuesday we go into session. So we have to have the discussion today.
Let's do our work sessions and see where we go. I appreciate that you need to leave at 4 and let's just be focused and keep moving forward. I appreciate that you want to have the discussion. I also know that we have spent a lot of time on our budget work and voted and reported to the Appropriations Committee, and that we also need to work on the bills that are before us today. And so
Chair Carney, when I raised the question last week or earlier in the week, I asked Representative Harnett, should we put it on the agenda? And he said, no, you have my word, we'll take it up. So, because it was going to be listed.
Didn't know that it was going to be sick.
I'm going to insist that we discuss it today. It was a promise made. Everyone heard it. And I hope the other members of the committee will back me up on this. Did anyone else hear it?
I heard it. I agree with you 100%.
Okay.
My concern is that Representative Harnett, who also wanted to participate, is sick today. He did not realize that he was not going to be able to join us. And also that we have to discuss, we have work sessions that were noticed to the public. And I also was not aware of your 4 p.m. deadline when I assured you that I would speak about it today. And I'm happy to speak with you anytime that you would like, if we are not able to meet your 4 p.m. deadline, which I would very much like to do.
Okay, well, we just wasted a half an hour waiting for the Democrats. I'm sorry.
Representative Libby, did you have your hand raised?
Yes, thank you, Madam Chair. I agree with Representative Evangelos that it is of utmost importance that we have this discussion today, given that we will not have another opportunity before we are to meet in Augusta to vote on Tuesday. And I understand that we have work sessions scheduled, but it seems to me that this would take precedence since it is a time-sensitive matter.
I'm only asking for 5 minutes.
Representative Moriarty, you have your hand raised?
Yes, Madam Chair. If the main motion is still on the floor, and if it's appropriate to discuss our positions on that now, I'll make a few comments.
Okay, go ahead.
The main motion from Senator Keim is ought not to pass. I will vote no, but in doing so, I want just to let everybody know that should the motion fail, I would then often offer a motion to pass as amended. And the amendment would be to basically delete each and every reference to clear and convincing evidence as it appears in the bill and replace it by preponderance of the evidence. And I don't want to confuse anybody with terminology, but preponderance is the least demanding evidentiary standard in our system. It's generally equated with proof of a 51% level of convincibility or believability. Clear and convincing evidence is much higher, and even higher than that, although it doesn't concern us today, is the third, and that's proof beyond a reasonable doubt. That applies only to criminal proceedings. So I would substitute preponderance of the evidence in order to, number one, secure that the presumption of entitlement to representation is still there, but that if there are circumstances in which the individual under guardianship really desperately doesn't want the attorney, there is a less demanding alternative to seek redress before the court. I also find it very hard to believe that a court, i.e. a judge, who has appointed counsel could be swayed by clear and convincing evidence that his or her decision was wrong. Possibly not so if the standard were lower. So those are my thoughts.
Thank you, Representative Moriarty. Representative Poirier?
Thank you, Madam Chair. I wanted to speak up because my profession is actually coordinating services for adults with intellectual disabilities. So I do have some firsthand knowledge in working with individuals who are actually subject to these sorts of proceedings. And my own research, spoken with a lot of my colleagues, and in working with these individuals, we try to instill values in them, that they have the same rights as everybody else. They have a right to choice, and we try to instill in them that they have a right to self-advocacy and supported decision-making. And that's something that the state itself is trying to promote, that supported decision-making process. And this automatic presumption is actually revoking those rights that we're trying to instill. So my position on this and the research that I've done, the system itself is working right now. The probate courts have systems in place that, like I say, they are working. Individuals that are going to the courts in guardianship scenarios, they generally have a team like myself and case managers who are working through the process with them. And in the small instances when they're, if you all remember in the hearings, we heard of small instances where maybe there's a family member taking advantage of the situation, that sort of thing. Generally, you're going to have a team member that recognizes that and is an advocate helping that person. So that's generally recognized and addressed. So just knowing this and supporting that self-advocacy and the rights to choice, I'm going to be voting not to pass.
Thank you for sharing your thoughts and your experience, Representative Poirier. Other committee members have discussion on this bill? Representative Sheehan?
Thanks, Madam Speaker. I just kind of wanted to respond with my concern that I have a lot of respect and gratitude for folks who work in this field. And I think that the issues, I'm sure that they're incredibly complicated. And I know that there are a lot of strong, dedicated advocates out there. But I just don't think that I'm ready to entrust disabled people's basic civil rights on the promise that everyone in this position is going to act in their best interest. I think that those rights have to be guaranteed. And although there's still probably some, space for issues, I think that the presumption of entitlement to counsel is sends an important signal that, that we are more concerned with protecting disabled people's civil rights than we're just as concerned with protecting their civil rights as we are with protecting anyone else's.
Thank you, Representative Sheehan, for sharing your thoughts. Do other committee members want to weigh in? Representative Libby?
Thank you. I appreciate Representative Sheehan's concerns, but I will be voting with, I'm sorry, we're on ought not to pass, correct? I will be voting yes, ought not to pass. I think this bill, in making a presumption of entitlement to counsel, it's actually forcing counsel. And in this context, it removes these individuals' right to autonomy and autonomous decision-making, which for some of these individuals is an incredibly, I would say for many or most of these individuals, is an incredibly important right. There are already a lot of rights and privileges that can be challenging to hold on to in this scenario. And the right to have autonomous decision-making is incredibly important.
Thank you, Representative Libby. Senator Kine?
Thank you. My question might be best for Peggy. I am wondering if the cost of this is then forced onto the counties to pick up the increased costs for lawyers. Would that be subject to a 2/3 vote?
So if it actually expands the activities of a local government and that those expanded activities have costs, then that would fall under the local government mandate, and you either fund it or you can waive it by a 2/3 vote. The language in this bill was actually part of the majority committee, is it a majority committee amendment from last year, and the fiscal office determined that there was no fiscal impact, which I'm because of the testimony that attorneys were already being appointed in cases in which they were needed. So the fiscal office looked at that and said, okay, if they're already being appointed, this changes the thought process, but it's not really changing how many attorneys are going to be appointed, if that makes sense.
It doesn't at all, but I understand.
Yeah, right. So the probate judges had said, our current law makes sure that we are appointing attorneys in every case where it's necessary, where an attorney should be appointed. But the language of the amendment said, here's how you get to that point. You assume you're going to appoint a lawyer, and then you don't if there's clear and convincing evidence that the person doesn't want it, and they don't wish to contest any aspect. So there was no fiscal note on this bill last year. I don't know if that will be the same analysis this year.
Thank you.
Representative Babbage?
I'll lower my hand now. Thank you very much, Madam Chair. Peggy, I also have one for you. I think current law has been carefully crafted, but I do support a default position being the appointment of an attorney. What I have for a question really is the threshold issue. If we should go to preponderance of the evidence in order to rebut the appointment, how would that compare in protection for the individual involved with the 4 specified reasons for guardianship that we currently have? Is there a possibility for me to clear and convincing? I'm not, I think we thought we could be expanding, but I wondered if preponderance would make it too easy to rebut comparatively to the status quo. I don't know if you understand what I'm getting at, but I'm trying to weigh.
I think I do, but what it takes to rebut that presumption, whether what you're talking about, Representative Moriarty said, here's how much weight you need to rebut that presumption. But in talking, we didn't talk about changing what it is that has to be proved, so to speak, or asserted. What the bill says is it's rebutted if the respondent or the adult knowingly and voluntarily refuses such representation and does not wish to contest any aspect of the appointment. So it's not the judge saying, oh, you don't need an attorney in this case. It's the person, the respondent, saying, I understand what I'm doing and I'm voluntarily refusing counsel in this case, and I'm not going to object to any part of this guardianship that's going forward. So it's, I mean, there's still some discretion there, but you're not changing the topic that is necessary to rebut that presumption. You're just changing how much it takes to convince the judge that the person really does not want an attorney.
Could it, let me ask, could the scenario be that a family member says, oh, he doesn't want an attorney, and then the person of interest says, okay.
I'll do whatever my son says.
Yeah, she's got, but she has, I agree with, she takes care of me. Is that a preponderance rather than the judge actually having a one-on-one with the would clear what I'm trying to identify what actually would be the difference in the threshold. Would the judge require a one-on-one to understand personally the desire of the person in question?
Right. Well, my understanding is that the judge would have to know that it was a knowing and voluntary, and that might require a one-on-one. It would depend on the circumstances of the case. And I know that Ms. Ayers said that in all these guardianship cases, they make sure that they are talking to the respondent. The respondent has to be present, either, on a Zoom meeting or, in person. And so they have that opportunity.
Does it have to be
whether or not they isolate them so they don't have the person who might be influencing them in the same room, I'm guessing that probate judges can be pretty savvy about what's going on in those circumstances.
Is the knowing and voluntary the standard for both preponderance and clear and convincing? Do you know?
So that's what this bill says is the respondent has to knowingly and voluntarily say they don't want an attorney.
Gotcha.
It's at what level. What you're talking about changing, what Representative Moriarty was talking about changing, was how much evidence does the judge have to have in order to overturn that presumption? Okay. Your standard's still the same, but how convinced does the judge have to be that is actually the situation?
I thank the patience of the committee, and Peggy, thank you so much.
Well, I hope that was helpful.
Thank you, Peggy, and thanks, Representative Babbage, for your questions. Representative Poirier.
Thank you, Madam Chair. And just to reiterate, Peggy, it's right now it's a visitor sees the person and then the judge also. So we do have that two-part scenario as far as people assessing it now.
Good point.
And then under the current proposed bill, the judge would have the say in who actually has to pay for the counsel that's being appointed. So even if the person said they did not want to have counsel, they could ultimately be forced to pay for it, correct?
That's true. If they have assets, right, and the judge determines that it's appropriate for them to have counsel, it would have to come out of that person's property.
Thank you.
Mm-hmm.
Representative Moriarty.
Just a small point, Madam Chair, and that is that we're not talking about proceedings to challenge the status of guardianship, conservatorship, or protective arrangement. There may be procedures available for challenging that elsewhere. But all we're talking about is knowingly waiving the right to legal representation in your proceeding, whichever one of the three it might be.
Thank you for that clarification. Committee members, does anyone have questions or comments? Representative Newell?
Thank you, Madam Chair. Could I ask Representative Mariotti to go over his proposed amendment once again?
Yes,
Yes.
go ahead, Representative Moriarty.
Okay, sure. In the bill that we have, it's just a one-pager, double-sided. It deals with an entitlement, a presumed entitlement to legal counsel in proceedings involving guardianship, conservatorship, and a protective arrangement. Guardianship, I recall from the earlier discussion, has much to do with one's health and well-being. Conservatorship, I think, is focused more on one's finances. And a protective arrangement, well, I have to yield to Jennifer on that it's a bit of a hybrid, I think. I'm not sure I clearly understand what that arrangement is. So it basically lowers if you're unhappy, if you are the person who is in one of those three categories, and you're unhappy that the court has given you a lawyer and you want out, the question is, what degree of proof must you carry in order to be relieved of your court-appointed attorney? It doesn't change your status as one needing guardianship or conservatorship. I hope that helps Representative Newell. It's the best I can do under very murky circumstances here.
Let me just ask this question once again.
All right.
You had mentioned there's a motion with a second on the floor with a pending vote.
Yeah.
You had mentioned, depending on the direction of that vote, you would introduce this amendment. Is that correct?
Yes, that's right. The reason I spoke up was to let everybody know that I have a plan B in mind if Senator Kimes' motion does not pass.
And Representative Newell, did you want to know what the specifics of that plan B are? Is that what you're asking?
No, I think I'm all set.
Okay.
Thank you.
Representative Poirier, is your hand raised for another contribution? Okay. Any other committee members have questions or points that they would like to raise in this discussion? Is the committee ready for the vote?
Yes.
Looks like it. All right. Soupy, welcome back to the panel. You may proceed with the vote, and this is the vote on the motion ought not to pass on LD 480.
Thank you, Madam Chair. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn.
No.
Senator Sanborn votes no. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckitt.
Pass, correct? So if I vote yes, I'm intending to have it not to pass. Is that what the deal is?
The motion was ought not to pass.
All right, yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell.
No.
Representative Newell votes no. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. I have 5 members voting for the motion not to pass, 7 members opposed, 2 members are absent.
Thank you
That is
very
fine.
much. I want to check in with the committee regarding the report for those who voted no. Representative Moriarty, could you please again restate your amendment? And then what I'll be asking committee members is whether the second report on this bill is ought to pass as amended or is just a straight ought to pass.
Okay, very well. I move ought to pass as amended, and the amendment would delete in each of the 3 places in which it appears, in which they appear, the words clear and convincing evidence, and replace them with the words preponderance of the evidence.
Okay, so Representative Moriarty has made actually a motion rather than doing this via a second report, which is, that's fine. That's fine. Is Representative Keim? I mean, Senator Keim?
Well, I believe the motion failed, right?
Yes.
So a new motion is in order.
Yep. So we have a motion by Representative Moriarty. Is there a second? Seconded by Representative Newell. Any discussion before we proceed to the vote? Go ahead, Representative Libby.
Thank you, Madam Chair. Can I ask Representative Moriarty to please re-explain briefly the various levels of evidence, the 2 that are at play here?
Yeah, of course, I'm glad to. The legal system recognizes 3 evidentiary burdens of proof. The least burdensome or the lowest threshold of proof to establish is called preponderance of the evidence. It's 51% or better. It's easily put in mathematical terms. The other 2 are not. The next higher level of proof is called clear and convincing evidence. It's tougher. It's hard for me to give it a percentage weight, but I'll just say it's higher than 51%.
Thank you.
And then the highest of all is proof beyond a reasonable doubt, which, depending upon who you talk to, is proof that's about 90 to 95% persuasive.
Thank you. That's very clarifying.
Hope that
I
helped.
appreciate the explanation.
Sure.
Thank you, Madam Chair.
All right, is the committee ready for the vote? Looks like we are, and thank you very much, Supi.
You, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
No.
Representative Galgay-Reckett votes no. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
No.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. 7 members voting in the affirmative, 5 members voting in the negative, 2 members are absent. That is the vote of the committee.
Thank you very much, Supi. That closes the work session on LD 480. Peggy, did you have something you want?
I mean, I think it's very clear in this case because we had an ought not to pass motion earlier, but I just want to make sure that everybody who voted no on the ought to pass as amended is going to be voting ought not to pass. So that will be the minority report. Is that correct?
Yes.
Okay, thank you.
Thank you very much. And again, I mentioned this after one of our votes this morning, but committee members who are absent do have an opportunity to weigh in with their votes. So the vote could change a little bit before it's finalized. And that concludes the work session on LD 480 and brings us to our next matter. And Senator Chipman had asked that we do 535 last. And so we'll move on now to LD 579. This is a resolve to conduct an independent examination of the protection order system to determine whether there is systemic misuse by applicants. And Peggy, could you please present us with the your analysis?
Yes, thank you.
Thank you.
So this bill is a resolve. I think this is the first resolve we've had this year, which directs the Maine Commission on Domestic and Sexual Abuse to do a study on how the protection from abuse law is working. 3 elements: review the laws and practices governing parental rights when domestic abuse is alleged or suspected, study whether the system supports a fair and just process for all parties involved, and study whether protection orders are being obtained for the reason the system intends, and whether de minimis violations of orders are being unfairly used against one party in the matter. The commission would be directed to invite interested parties, including the Family Law Advisory Commission, the Maine Coalition to End Domestic Violence, Guardians Ad Litem, the Family Law Section of the Bar Association, the Judicial Branch, the Maine Association of Criminal Defense Lawyers, and others the commission determines helpful to the study. The commission would do the study and submit a report to this committee no later than December 1st. And the Judiciary Committee would be able to report out legislation to the second regular session based on the report. There is a mistake in my bill analysis. It says the commission is authorized to report out legislation. That's not right. It's the Judiciary Committee would be able to report out legislation. So this is kind of building on a study and a report that the Maine Commission did in 2010. And I think I had given you a link to that report. And that study was actually a little bit more extensive, didn't focus on exactly the same things, but it did. One of the questions was whether misuse of the protection from abuse process is happening, and if so, why and to what extent it's occurring, and what are the problems with the process itself. The report ended up, I don't believe there were statutory recommendations that came from the report. It was a fairly extensive study and report. There was testimony that perhaps the report hadn't covered all the information or characterized the information that had been collected. And then the governor's office actually opposed the resolve, and folks neither for nor against, including the commission itself, suggested that if you were going to go ahead and do a study, that you might want to refocus what it looks at, and also provide some resources to the commission to carry out the study, and maybe be able to pull some experts in who would be able to help kind of either design the study or do in-depth analysis. I don't think I have anything else for you.
Thank you very much. Representative Reckitt?
Yes, I'd like to move ought not to pass.
The motion ought not to pass. Representative Thorne, did you wish to be recognized?
Yes, Madam Chair, thank you. And again, I seem to be caught off guard. I didn't realize this was a predisposed conclusion that we were going to vote on this right out of the gate.
Well, you don't vote.
So we can,
You can vote.
after there's a motion, we can have ample discussion, questions of the legislative analyst, just like the last bill, where we had a very early motion and then a robust conversation.
So would now be the time to ask if there's a fiscal note attached to this? I don't have it in my notes.
Yeah, that's a good question. And then once we answer that question, we'll see if anybody wants to second it. Peggy, do we have a fiscal note yet?
I do not have a fiscal note yet.
Okay.
Thank you.
Yeah, thank you.
Did you have a second on the motion?
Not yet.
Yeah.
Is there a second on the motion? I see a number of them. Representative Sheehan is a second.
I
Representative
can explain if you would like why I made this motion so quickly,
Yes, please.
or I cannot. Either way, it doesn't matter to me.
I'm recognizing you, Representative Reckitt. Go ahead.
Well, once I calmed down from reading from this hearing, because of course as you will note, if you read the analysis, I'm named in this as someone who was prejudicially inclined when this last bill was headed up and personally screwed up the study by the commission. I have not been on that commission for 15 or 20 years. So how it was that I, in the commission, changed this, I have no idea. My wife, who is also mentioned in the analysis, which she was not at the time of the study, has never served on the commission. So I have no idea where that allegation comes from. I do know that I have looked at this study in some depth, and I know the issue fairly well. And what I noticed is that when the freedom of access filing results came back and noted that I think it was 172 respondents said that they saw a willful misuse of the PFA process, there was no delineation about whether that willful misuse was being done by the victims of domestic abuse or the perpetrators of it. And I would tell you from talking to bunches of these folks that the reality is the preponderance of misuse is coming from the persons accused of the abuse. So the fourth thing is that there is no fiscal note, which means we're asking a commission that is unfunded, I might add, to use significant portions of their own monies, which they have none of, to carry out this report. And I know there's no laws about unfunded mandates onto voluntary bodies, but good luck. And I don't think it's fair that you would ask them to once again do what would amount to, even at the minimal state, a $10,000 or $15,000 study with absolutely no resources to do it with. So for all of those reasons, I am urging you, frankly, not to waste any more time with this issue and move on. Check.
Thank you, Representative Reckitt. Representative Thorne, your hand is raised. Did you want to contribute to the conversation or ask questions?
If I may, Madam Chair, that would be great in helping me to educate myself on this bill, which unlike the the good representative seems to have a lot of background knowledge on it. And she had mentioned that this 179 respondents may have been from those who had committed the misuse rather than the victims themselves. And in my head, I'm thinking, well, what more reason than to do a study, regardless of who's misusing the system, than if it is someone who did misuse, who's misusing the system. It seems like a twice-fold violation to me, but maybe I'm missing the point of what she's saying as far as being a waste of time. So that's my only question. Thank you.
Might I respond, Madam Chair? Could I, might I clarify?
I'm muted. My bad. Go ahead.
The reason I said that, Representative Thorne, is that my experience, and you're right, I have a lot of experience. I've spent 37 years working in this field and several years volunteering before that. So I have about 40 years of experience. I was around when the first protective order legislation passed. I was involved with that passage. And I have watched the people coming forward asking for help from domestic violence agencies to obtain a protective order. Those people are predominantly women. I have also watched, it's an interaction really in some ways with Pine Tree Legal because they're a law firm, they can only represent one party. So sometimes the perpetrator of the abuse would go to Pine Tree Legal for assistance and thus block their wives from getting assistance from them. So they would have to depend on us for non-legal assistance to help them figure out a way to advocate, to navigate the courts. But it's also a way to try to dampen the credibility of the victim. And it has increased as the public consciousness of this crime has risen and the things that can be done about it. There has been a shift of people trying to misuse I believe, trying to misuse the process, but it's not significant enough, frankly, and is being handled routinely by those who understand it to launch a study. I would say that probably there are 8 domestic violence programs all over the state. I would say each one of them probably sees 2-3 cases a year where that's happening. And they only see that because they're trying to help the other side of the equation. So I don't think it's a large enough problem from that side. I happen to know that the people who were many of the people who were testifying and who presented this bill may not have the same attitudes about domestic violence as I do, and certainly don't have as much experience. And so I think that their opinions are not credible to me. So I'll quiet there before I say something I wish I hadn't. But I just don't think there's any reason to do this. We did it 10 years ago. If we did a study every 10 years on the same thing, people would tell us we were wasting money all over the town. But there is no money to do this with. I don't believe. There are a limited number of studies that the state can fund each year out of appropriations. And I don't think we should ask that this be one of them when I don't believe it's needed. Thank you.
Representative Thorne, is your hand up because you would like to continue to speak, or are you all set? And Representative Reckitt, could you please look? Yeah, thank you. Representative Moriarty?
Thank you, Madam Chair. I'll be voting in support of the motion ought not to pass for several reasons. First of all, according to information provided to me by Peggy, we have a standing committee already. It's the Maine Commission on Domestic and Sexual Abuse, which consists of some 36 members, representing a broad variety of people from with experience in this arena, if you will, as well as professional experience from a broad range of backgrounds. The bill would add at least 6 more members to this 36-member committee, making it quite large and unwieldy in size. I'm not sure that's a step in the right direction. Also, the bill imposes a December 1st, 2021 report date. If this commission, if the existing commission cannot invite new members until, should the bill pass and be signed, if the commission cannot invite new members until after the statute becomes effective, there's almost no time in which to get this work done by the bill's deadline. I think we have a watchdog in place. I think we have a commission whose members hopefully have their ears to the ground and are not shy about coming forward with problems and issues that they think are prevalent and of concern. So I don't think the bill is necessary.
Thank you, Representative Moriarty. Other committee members, are there, excuse me, questions or discussion of this bill? Not seeing any. Is the committee ready for the vote? Looks like the committee is ready for the vote. Thank you, Supi, for returning. We are voting on LD 579. Oh, excuse me, Representative Evangelos.
I'm sorry, Madam Chair. I just had a quick question for Lois. She will be able to help me with this. Aren't judges already, supervising anyone who's misusing this? That's a level of protection, isn't it?
Yeah, well, the judges hopefully could ascertain whether it was being misused. They certainly don't. It's not a routine grant. Even the initial temporary order is not that routine. It still has to be signed by a judge, and the year-long order has to be has a hearing before a judge. So my belief is that 99% of the time, judges can get this right.
Thank you for that.
Would any other committee member wish to raise a question or be heard on this matter? Not seeing anyone. And so the pending motion is ought not to pass. And Supi, thank you very much for taking the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
No.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. 9 members voting in the affirmative, 3 members voting in the negative, 2 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And what is the report for Representatives Libby and Thorne and Senator Kime? Is it?
It's simply ought to pass.
Thanks. Thank you for the clarification. Representative Babbage, I was going to close the work session first. Do you need to speak before then? Okay. So this concludes our work on LD 579 and the work session is now over. We are going to move on to LD 622, but I want to recognize Representative Babbage. His hand is raised.
Yeah, thank you very much, Madam Chair. I just want to take the opportunity to clarify so that there's no misunderstanding about motive or anything else. You know, as a 40-year history teacher and teacher of parliamentary procedure, and sixth-term, maybe that's where I learned this more so. Work sessions are about hearing, the analyst's summation and analysis and asking questions of information and making statements of advocacy and persuasion. And a motion is appropriate at any time after the analyst's presentation. And then, of course, a second is in order, and then we have discussion. And we don't have a vote on the motion until it's the pleasure of the committee. So usually you have a motion on the floor as a way of targeting what we are discussing, and so that the membership can ask the questions that they need in order to vote as they wish on the motion. Regarding predisposition, I think we all come to any meeting with however we're predisposed, but it's merely a parliamentary procedure to have something on the floor prior to discussion. So there's no malice of intent or anything like that. I just wanted to bring that to the awareness of the full committee. Thanks.
Thank you, Representative Babbage. Representative Libby?
Thank you, Madam Chair. I just wanted to thank Representative Babbage for his explanation. I think those of us who are new have missed out on some of these conversations doing this via Zoom, and I appreciate Representative Babbage going into some detail there. It's appreciated.
Thank you. All right, committee. Is the committee able to continue to proceed without a recess as we move on to our work session on LD 622? Looks like everybody's fine. We'll open the work session on LD 622. And Peggy, would you like to present the bill analysis, please?
Yes, thank you very much, Madam Chair. So LD 622 is an act to prohibit marriage of any person under 18 years of age. Current law says that anybody who is under 18 years of age or who's under 18 can get married with the written consent of their parents, guardians, or persons to whom a court is giving custody. And in the absence of those persons who are qualified to give consent, the judge of probate in the county where each minor resides may grant consent after notice and opportunity for hearing. And the law prohibits the issuance of a marriage license to a person under 16 years of age. So that's the current law is under 18, you have to have the parents' consent or a judge can provide consent, a probate judge can provide consent. But under 16 can't be married in the state. This bill would take out that 16 opportunity completely. I mean, it would say you cannot get married under the age of 18. So you no longer need consent because you can't get married under the age of 18. And that's that's what the bill does. There was a DHHS report a couple of years ago. There was a bill to raise the age where parties could be married with consent. I believe it was 15 at the time, and now the legislature did change it to 16. But also asked the Department of Health and Human Services Vital Statistics to look at their marriage statistics. I did include that in the bill analysis. It's really a one-page report. They went back and looked at 2014 to 2018 statistics. In 4 marriages, let's see, 58 had at least one party that was younger than 18 years old. In 4 marriages, both parties were minors. No parties were younger than 16 years old. 9 individuals were 16 years old. And that's what they reported in 2019 for the years 2014 to 2018. I think some of the people who testified had some more recent information.
Thank you. I'm sorry, did I cut you off, Peggy?
Oh, no, I was going to say I can go over that, or you probably understand all the testimony. There was a lot of testimony. There was a long hearing.
Thank you. Senator Kine?
Thank you. Peggy, do you remember why the department wasn't able to give us more current data? Because I think they had to go back into, from last time as I'm remembering, they had to go back into physical records to get some of the older information, but now it's all filed online, and I thought it was simple to pull a report.
I don't know. And I don't know that we actually, I certainly did not ask them. And I suppose I could have asked them to provide information. I'm just looking to see if I have any testimony from the department at this point. And I don't think I do.
Is there any aspect of the analysis that committee members would like to see on screen share, or is everybody all set with that? Looks like everybody's all set. Are there questions among committee members for Peggy? Not seeing any. Is there a motion? Representative Moriarty?
Thank you, Madam Chair. I move ought to pass.
I just want, I'm sorry for stumbling. Senator Keim, could you please let me know whether your hand was raised or before Representative Moriarty's? Because I feel like I saw his hand and I didn't know if yours was up first.
I don't know, actually, and that's fine. I was going to make the opposite motion, so it's fine.
Okay, thank you very much. So we have Representative Moriarty's ought to pass motion, and then Senator Sanborn, did you raise your hand as a second? So motion by Representative Moriarty, seconded by Senator Sanborn. Is there a discussion of the motion? Go ahead, Representative Libby.
Thank you. I didn't realize I was unmuted this whole time. I apologize. Thank you, Madam Chair. When we are passing legislation, we are seeking to fix a known problem. During the public hearings, we did hear substantial testimony from out-of-state organizations regarding forced marriage of 13 to 15-year-olds, or even younger. And I fully agree that marriage at these ages is very likely forced and is egregious. That is already settled law here in Maine. It was also asserted that forced marriage at 16 and 17 is a problem here in Maine, though this was not substantiated by data, which I asked for numerous times. While we might not have data to back up claims that all 16 and 17-year-old marriages are forced, I would like to read you a brief email that I received from a Maine resident. Senator Carney, Representative Harnett, and distinguished members of the Joint Committee on Judiciary. My name is Wendy Munsell, and I live in Livermore. I ask you to vote ought not to pass on LD 622. My interest in seeing this bill defeated comes from my own experience. In 1977, at the age of 17, I married the love of my life. 43 years later, we remain happily married. We've raised our family of 7 children here in Maine, and we look forward to greeting our 23rd grandchild in July. In general, I believe that most 16 or 17-year-olds are not ready for the levels of responsibility and commitment required to make a marriage successful. But there are exceptions, as my husband and I have proved. Please allow the citizens of Maine the freedom to continue making this important decision themselves. Having read that testimony, I can tell you that this woman who married an adult man when she was a 17-year-old is my mother. While I can't deny that we might not have faced the financial struggles that we did at times if my parents had had college degrees, my siblings and I are living proof that marriage at a younger age can be successful. Without a preponderance of compelling proof that such marriages are, in fact, forced in Maine, I am loath to remove a right from our Maine citizens. Thank you.
Thank you, Representative Libby. And also, please extend your thanks to your mother for sharing her story with us. And I appreciate you sharing it with us today as well. Representative Thorne?
Yes, thank you, Madam Chair. I'll lower my hand while I'm thinking of it. And if the committee will indulge me, I too have a personal story. I was married on my 18th birthday. I had both my parents sign my consent form to be married to my wife of 12 years, which I have 2 daughters, 2 grown daughters, who each now have 2 daughters, a daughter and son each. I was also needing consent to join the United States Air Force, of which I spent 21 years of my life when I signed up at 17 years old. I decided to become a legislator for a lot of different reasons. But, excuse me, to take away the rights of Maine citizens, regardless of their age, and to prohibit them from indulging, we might as well just pass bills prohibiting them from getting bad haircuts, prohibiting them from buying bad clothes and making bad decisions. It sends an awful message to those who would voluntarily want to marry someone that it would be illegal. And I'll stop there, and I think I've made my point, and I will be voting against this bill as proposed, as ought to pass. Thank you.
Thank you, Representative Thorne, and thank you for sharing your experiences with us. We really appreciate you. Representative Babbage?
Thank you, Madam Chair. It's always political suicide to follow moving and testimony as we've heard, both from Representative Libby and Representative Thorne. But my perspective on this bill, and I have to say, my predisposition, if I had one, was to not support this bill because just because of this is a bill of consequence. There's no doubt about it. But you know, having taught the American story, and for a huge portion of that story, women being legal property, chattel, and I also believe, other cultures have arranged marriages. And when a parent says to a 16 or 17-year-old, you're pregnant, you're getting married. That's an arranged marriage many times. And arranged marriages succeed. But I have a problem with the person who is not legal to sign a contract to be put into a contract that has great lifelong ramifications, and we all know the data of that. So you know, I I too have a story. When I was a senior, I went steady for 6 months, and then went to college and didn't see the young woman for 3 years. But I did resume that relationship, and we have a 47-year marriage. I guess the difference is that I didn't ask her to marry me when she was a minor. And hopefully she didn't regret her decision as an adult. But my point, I think the point is, I thought that the testimony we heard was compelling. And actually, my mind was changed in the process of whether this is a timely decision for us to make on the part of the state or not. I do think a person not being compelled into a relationship until they are of age is not a bad thing. And so that's how I'll be voting. Thank you. Appreciate your indulgence.
Thank you, Representative Babbage, and thank you too for sharing your personal experiences with us. Senator Keim?
Thank you. Yes, I'll be voting against the motion. I believe this bill ought not to pass because, well, first of all, we don't have evidence that shows that it's needed. We had a large amount of out-of-state people coming in to push a perspective that I think is influenced heavily by religious practices in other countries that possibly is being brought into Maine in some manner through immigrants. But if it is happening, it's not apparent through the data that we have. And there is, in addition, no further factual information to back up that the marriages that are happening in Maine are of young people are somehow detrimental to them. We just simply have a few numbers out there. And then we have stories of people that they've brought us where things have not gone well, but we also have stories where things have gone very well. So for us to portray and then push on every Maine person who happens to be under the age of 18, our belief that they don't have the maturity to enter into this, even though their parents have to be involved in the decision and give them permission. We're saying not only is this underage person incapable of making their own decision, but their parent is also incapable of making a good decision. And it's a very blanket way to create law to deal with a few bad stories that have come to us. So, I mean, I could share stories of where things have gone well, and I think we all know them. But I think to take away the liberty of Maine people and parents, take away their liberty based on such thin evidence is really an overreach on our part.
Thank you, Senator Keim. Senator Sanborn?
Thank you, Senator Carney. So I believe this is a human rights issue, and I also want to just point to the fact that that we're talking about civil marriage. We're talking about what the government is going to recognize, and what the government is going to contractually obligate you to for the rest of your life until such time as you go through a dissolution process through civil proceedings using our courts to get divorced. I don't think that anyone under the age of 18 should be in that position, because I don't think parents should consent for their kids to do something that binds them after those kids turn 18. And I too am married happily for more than 20 years to someone I started dating when I was 16. But we didn't get married until well after we were 16. And I'm happy with that decision. And I don't think that there's a question about my liberty that's at stake. It's really a question about human rights and about ensuring that our kids have their autonomy preserved for them until they're of the age of majority in order to be able to truly make their own legal decisions. We've agreed that's 18. Certainly some kids could drive a car when they're 14, but we've decided that 16 is the right age for that. We decide when we determine certain governmental privileges are going to be available to our citizens. And voting comes into play at 18. And I think that's the universal age of majority in this culture, at least for most things. So I think 18 is the correct age. And I will be voting in favor of the motion.
Thank you, Senator Sanborn. Are there other committee members who either wish to raise questions or wish to be heard on this matter? Representative Poirier?
Thank you, Madam Chair. The reason why I'm going to vote against the motion is not necessarily my own personal experience, but a family member's. And it does go along the lines of some of the other stories that we've heard here today as well. But my sister was married at 17 with my parents' consent. And it was because she was turning 18 6 months later, but her husband-to-be was entering the military. And in order for her to be allowed to live on base when they got made, when he was stationed, they had to be married. And without that marriage in place, they would have had to wait several years in order to live together. That's the way the military worked. So with this law in place, we're telling people also that they're going to have to wait several years to get married. So that's something to consider as well. In those scenarios, I mean, is there going to be any play in this law the way that it's written? Is there anything written in this law that would be an exception for that sort of scenario? I guess is a question, because there are legitimate reasons for a person to have that need fulfilled. I don't know if Peggy could answer that perhaps, but I think those are things that we should look at before we just blatantly pass it, not knowing. Thank you.
Thank you, Representative Poirier. Peggy, did you want to answer the question?
Right. I don't think that as written, there is any exception. That the bill would require, prohibits the state registrar of vital statistics from issuing a marriage license to a person under 18 years of age. So I don't think that there would be an exception in those situations.
Did you have other questions, Representative Poirier?
I think that covers it. Thank you.
Yeah, thank you. Thank you for raising the question. Representative Evangelos?
Thank you, Madam Chair. Peggy, do you know what the laws are in Massachusetts and New Hampshire by any chance?
Not right this minute.
I mean, because if the kids can't get what they want, they have the option of running for it. Two 17-year-olds are in love are totally capable of hopping in a car and leaving. So I didn't know if like New Hampshire or Massachusetts had that availability.
It looks like Massachusetts allows marriage under 18 without with parental consent.
Okay.
Without a minimum age. And you said New Hampshire?
Yeah.
it looks like the minimum age was raised to 16 in New Hampshire in 2019.
Right. Thank you.
Peggy, in New Hampshire for people ages 16 and 17, is there any parental consent or judicial involvement in New Hampshire?
You know what? I am not looking right at the statute. So if you could give me a couple minutes and let me track that down.
Thank you. Yeah, I will. I will. And I just wanted to make a couple of announcements. There have been a couple of contributions to the chat, and I just want to remind people both in the panel and in the attendee space that because of the nature of work sessions, which are really focusing on members of the committee discussing legislation among ourselves, we typically don't have the same kind of testimony. We actually don't have the same kind of testimony that we have at a public hearing. And in addition to that, the chat feature is really only used to raise technological difficulties. It's not a substantive contribution to the work session or in the event of a public hearing to a public hearing. I also am remiss, I wanted to convey to the committee that Representative O'Connell wishes that he could have been here for the work session. However, he had to work today and was not able to attend. And Ms. Goodwin, he reported, is in school today and is not able to attend. But he did ask that I forward that along to committee members. And so I wanted to let you all know that. Representative Moriarty, do you wish to be heard?
Yes, thank you, Madam Chair. Fellow members of the committee, I did not make my motion out of any sense of paternalism or sense that I necessarily knew better than anyone else about these things. I fully respect the personal stories that Representative Poirier, Representative Libby have shared with us. I also acknowledge the testimony that we received at public hearing on March 18, which told some, in rather moving fashion, some bad experiences that people had, which they categorized as a human rights abuse. As males and females progress through adolescence into adulthood, we do in fact draw lines in our legal system, some of which have been mentioned. There is the legal driving age, the legal age at which you can enter the military without parental consent. Later on in life come the minimum ages for drinking and smoking. And gosh knows we've had a lot of talk already this session about juvenile law. And in the context of juvenile law, the point is made over and over to us by a number of experts and those who practice in the field that people under the age of 18 have not attained full mental maturity, if you will, full responsibility for making clear-headed decisions about their welfare and the safety and welfare of others. And I just think that this falls into that same general category. And I think it is the better practice, and it is more in keeping with our traditions and values, and it promotes health, well-being, and the fullest of opportunities for both the young persons who potentially could be involved in an early and possibly ill-advised marriage. Thank you.
Representative Libby?
Thank you, Madam Chair. I do have a question. Representative Moriarty and Representative Thorne have both brought up the issue of military service, and to my detriment, having never served in the military, I am curious. I'm not familiar with the laws, so I wonder if Peggy, if there's anything you could tell me about what is the age at which one can enlist with the permission of one's parents. I realize this is usually a male scenario, but these days anyone can enlist, and I'm curious at what age you can agree to literally fight to the death for your country with your parents' permission.
I don't know what that age is.
It looks like
Looks like
Representative Thorne does.
Representative
Mrs.
Thorne might be able to answer the question. Representative Thorne?
Thank you,
Thank you, Madam Chair. Having been an Air Force recruiter for 10 years plus, I can tell you that the legal age is 18 without parent consent. Other than that, it is 17 with parent or guardian consent.
Thank you. Thank you very much, Representative Thorne. Did you have your hand raised to contribute to the discussion as well as to answer the question?
Thank you, Madam Chair. I actually did before that question was asked, and it was more or less in response to Representative Moriarty's comments, which prior to that, I hadn't planned on making any additional comments, but for us to presume that anyone under 18 is incapable of voluntarily knowing or being able to make decisions for themselves that are best, I think that's very presumptuous of us. And I think it's very self-righteous of us. In this day and age, we want to make sure that, yes, human rights are addressed. And I don't want to get off on a tangent, but I think we need to address the fact that, and maybe Peggy would be able to answer it, how long has it been that Maine has been in that current law status of 16 years of age, where individuals have been able to get married under age 18? Do we know how long that's been in effect?
It was under 18. It was changed just 2 years ago, PL 2019, Chapter 340, where the minimum age, I think, was 14, and the legislature changed it to 16.
Okay.
With parental consent.
Thank you. And I'm thinking of the history of the state of Maine. I know there's good cases and bad cases in any scenario, but for us to make this precedence in the year 2021 of our Lord, I think that speaks volumes of where we are regressing as a society if we're taking away more rights of our citizens than we're granting them. That's all. Thank you.
Thank you, Representative Thorne. Representative Sheehan?
Thanks, Madam Chair. I just wanted to offer my understanding that these rights and responsibilities are not actually vested in young people under current law. These actions can't be taken without parental consent, and I'm really sensitive to the issues that Representative Thorne and others are bringing up. I think we could probably have a pretty interesting conversation about the bigger picture questions of the age of majority. But current law does not grant 16 and 17-year-olds these rights. It grants that right ultimately to their parent or guardian. And I think that's where I have serious concerns about it. Thank you.
Thank you. Representative Reckitt?
I'm sitting here trying to think about what might be a middle ground in this. And I'm trying to think back to the laws that have to do with child sexual abuse, which doesn't happen if there's a certain amount of time, age difference between the two parties. And I think it's at a particular age, it's like if they're within 2 years of each other, then it's not a crime. And so I'm wondering whether it's possible that we could do this, but say that anybody, you see the drift I'm going to. I'm trying to figure out whether or not there's an age difference between the two parties that might make it less dangerous, frankly, in my view. I don't know the answer to that question. It's just what I'm trying to think through as I look at this piece.
You all set, Representative Rackett?
Yep.
Representative Evangelos?
Thank you, Madam Chair. And along those lines, I remember in the 1960s, we lowered the drinking age and the voting age to 18 because the men and boys were being drafted into the Vietnam War and they couldn't vote and they couldn't even drink a beer. So I think the compromise sounds reasonable at 17 years old. I mean, if they can go into the military and lose their lives, I guess they should be able to have the right to marry their fiance before they leave for the military service. So I don't know how we're going to get around this, but Representative Thorne got me thinking about what happened to us in the 60s. It was outrageous. We couldn't vote or drink until we were 21. So we changed that for that reason. And if they can go into the military when they're 17, I wouldn't have a problem with a compromise at the 17-year-old level, along the lines I think that Lois was suggesting. But that's just a suggestion. I think there must be a motion on the floor. I don't know how we're going to get around it, but that's a compromise. Thank you.
Thank you, Representative Evangelos. Yeah, the pending motion is ought not to pass. And it was, excuse me, ought to pass. You're right. Excuse me. The pending motion is ought to pass by Representative Moriarty. And I don't know that he would accept an amendment, but we should ask him. Representative Moriarty?
So the proposal, I believe, from Representative Evangelos is to substitute 17 years of age for 18 in the draft bill.
Yeah, that is correct, only because they're able to go into the military and lose their lives.
With consent, of course.
With consent, yeah. It's Mr. Thorne, Representative Thorne said that they had to have consent to go into the military at 17. So that would put those two things together.
Right.
It's just a suggestion
yes, I
around the
understand.
dilemma we're in. But I just remember what happened to us in the 60s, and so do you, Representative Moriarty.
I was there as well. But I was 22 before I went in the Army, so it didn't apply.
No, you got a college deferment.
I would accept that amendment.
Senator Sanborn?
I would really urge us not to accept that amendment. I mean, we're talking about an international standard for human rights that is, taking hold across the world, and we really shouldn't deviate from it. 18 is the age of majority. It's the age when you can sign a contract, when you can sign a check, and it's the appropriate age where civil marriage should be blessed by the state. So if the amendment is altered, I will vote against.
I likewise would vote against the amended motion, which we don't have we don't have a second yet on the proposed amendment. Representative Newell?
Thank you, Madam Chair. Might I ask Peggy to verify the age allowed in the state of Nebraska?
Okay, just to catch you up, it looks like New Hampshire is 16 with parental consent.
Nebraska.
Yeah, so Nebraska.
Peggy, thanks for doing the research for us on the fly here. We appreciate your.
This is one of the benefits of meeting via Zoom, right? Minimum legal age with parental consent is 17. I'm not sure. I believe this minimum legal age without parental consent is 19 in Nebraska.
Oh,
I'm not looking at the Nebraska statute. I'm looking at a summary of that, but let me just look that up directly. The New Hampshire website is our firewall won't let us get into the New Hampshire website, just so you know, for whatever's going on there. Okay, in Nebraska, at the time of marriage, the male must be the age of 17 years or upward, and the female age 17 years or upward. And if you have a venereal disease, you can't get married. And marriage ends the person's minority.
that's an interesting wrinkle.
It sure is.
Representative Knoll, did you have a follow-up question or contribution to the conversation here?
No, I just wanted to verify that in the state of Nebraska, I kind of picked it up that it was age 19. And I think we're seeing more and more states implementing the age 18. And I think there's currently, 3 or 4 states already. And I did read, I think in the testimony, that there is a congressional bill being proposed, but I couldn't locate that.
Thank you.
If I might speak, I'm
Hang on a
I'm
second, Lois, 'cause I think
intrigued
there
on.
are some others that are ahead of you in the queue here. I'm apologize for interrupting. I think it was Representative Babbage and then Senator Keim and then Reckitt and then Moriarty. Go ahead, Babbage, Representative Babbage.
Thank you, Madam Chair. Yeah, I was pondering Representative Evangelos's thought. Certainly, one of the grievances, of course, was not being able to vote and being overseas. I think the military, the mention of the military is certainly relevant, but it is interesting that society, rather than raise the age of military experience, chose to lower the others. The draft age during Vietnam, be reminded, it was 19 to 26. That was the eligible. So 19 was the minimum for the draft in the military. So I'm thinking that in a time of war, and you could argue about Vietnam, but in a time of war, everybody is called to arms. But in a normal process, the military observed 19 as the earliest age of a draftee. So, thank you.
Thank you, Representative Babbage. Senator Keim, did you want to make a contribution? You had your hand
I will
raised.
after.
Okay. Representative Reckitt, you are next.
Well, what I'm now thinking about is were we to leave the law as it stands and only add the sentence that just came from, I can't remember which law Peggy was reading, where marriage at that age automatically conveyed on you majority status. It would be less disturbing to me, because one of the things that's disturbing to me is you could, under the current status scenario, you could be forced to get married, but you would be unable to file for divorce, which really makes me a little crazy. So I'm wondering whether that might be part of the cure of this thing, is to say that, yeah, you can get married, but you're also now an adult. And so you can do whatever you do as an adult. And Lord knows I'm not an attorney and I have no idea how you would do that, but that's just another thought that's flying in.
Thanks for sharing that, Representative Evangelos, and then Senator Sanborn.
Thank you, Madam Chair. Chris, the Selective Service Act of 1948 required us to register the draft upon our 18th birthday, and we were immediately eligible to be drafted at 18 years old. Just Google Selective Service and the history of it. It's right there. It was 18. I remember going to the draft board. If you didn't, they came after you. And you went when you were 18. That's all there was to it. It wasn't 19.
May I respond, Madam Chair?
Madam Chair, I've got the link up right here, and I'll read it to you. The Selective Service.
I don't think that is actually.
I'm just making a correction. It wasn't 19, it was 18, and that's the basis of our argument here today. So just want to get clarified on it. I'm not advocating, I'm just clarifying his point.
Yep, I appreciate that. Appreciate you looking it up. I don't think we need to resolve that right now because we've got a bill before us that is about the minimum age of marriage in 2021. And Senator Sanborn, do you want to proceed?
Yes. Yes, thanks. I wanted to address Representative Reckitt's suggestion that this was somehow about whether a 17-year-old or 16-year-old is then no longer a minor. That's already the law in Maine, that as soon as you are married, you are emancipated. It's the only circumstance where you could be emancipated without a court order specifically meeting the criteria for emancipation.
Thank you for that.
Once you're emancipated, you can enter into contracts like a lease. If, you can do a bunch of things, but you're still not allowed to drink alcohol or smoke or vote.
Anyway, thank you for the information.
If I could just follow up on Representative Newell's question about Nebraska. Nebraska's age of majority is actually 19. And that must be what she was. So anything under 19, you need parents' consent, but you can't get married under the age of 17 in Nebraska, even with parents' consent. Just to bring you full circle.
Thank you. That was helpful. Thanks for tracking that down for us, Peggy. Committee members, does anybody else have any additional questions or points that they want to contribute? Go ahead, Senator Klein.
Yeah, I just wanted to bring up one other because Representative Newell and others have brought up like different societal trends and how, maybe that should inform our decision on here, and that other, places are increasing the age of marriage. And Senator Sanborn mentioned that this is a lifetime contract that, we would be allowing someone to enter into before they actually can make that decision on their own. And yet what I've noticed also when we look at societal trends is that, there was a bill in DC that allows school-age children to decide their own vaccinations, and that passed. And I know that we allow here in Maine children to make really substantial medical decisions for themselves, such as abortion. And I think another societal thing that's been coming and being pushed and probably advocated for, maybe even by some members of this committee, is different methods of sex change or choosing sex. And those also have lifetime ramifications. So it's hard to justify, saying that this is a lifetime impact that a child and their parents shouldn't be able to make when, divorces are actually pretty easy to come by in Maine. And I think that we don't see, again, as I said before, the negative impacts on children that are doing this.
Thank you, Senator Keim. Representative Moriarty?
Thank you, Madam Chair. I just wanted to respond to Representative Reckitt. I don't know of any reason why someone who is married under the age of 18 could not seek a divorce while still under the age 18. You don't have to be to have achieved a majority to file a complaint for divorce if in fact you can legally married. And again, I'm just thinking of the juvenile situation. If we do not impose all of the consequences of a criminal conviction upon someone under the age of 18 for what otherwise would have been a clear criminal violation, it is a rather express recognition, in my view, of the fact that people under that age are just not fully capable of making the best decisions for themselves and do not have fully developed brains, as it's also often said, or fully developed decision-making capacity. And again, we see that reflected in other aspects of society as well in terms of age delineation. Thank you.
Is the committee ready for the vote? Looks like nobody is objecting to moving toward the vote. So the pending motion is ought to pass. The motion was made by Representative Moriarty and seconded by Senator Sanborn. Everybody ready to vote? Representative Evangelos?
Didn't Representative Moriarty make another motion?
Representative Moriarty, could you address that question, please?
Well, I said I would not, I would consent to the suggested change, but that itself was not seconded. So I understood the chair to rule that was something that was not on the table because it wasn't seconded.
Was a second asked for?
Yes. Or I should say that the chair mentioned that it had not been seconded to the point at which she was speaking, and it never came after that point.
So we have a motion that was seconded and a motion that wasn't seconded on the floor.
Yeah, that's right, yes. So the main motion is simply ought to pass.
And Representative Evangelos, I understood that you were making a motion to amend Representative Moriarty's motion and that it never received a second. And if I am incorrect, I would appreciate a member of the committee setting the record straight for us before we take the vote.
Yeah, I'll set it straight. I didn't make any motion at all. I was making a suggestion for the debate, and Representative Moriarty picked up on it. I guess it all got a little confused at that point. I was just making clear about where we stand and what we're voting on. We did have two motions on the floor. One, I guess, that wasn't seconded, but I think what happened was debate intervened and we never got to a second. So I'm comfortable with the compromise, but and I'll second it if you need a second, but I don't want to gum up the works here. You have a motion on the floor. We can vote the way we want and take it from there.
Senator Sanborn?
Maybe I can help clarify, which is that I was the second on Representative Moriarty's motion, which was the pending motion. And you suggested a friendly amendment to Representative Moriarty's motion. He would have accepted it, but as the second on the pending motion, I would not. And so I did not accept it as a friendly amendment. And then Representative Moriarty did not withdraw his motion. So the current motion is the original motion by Representative Moriarty. And that's the one that we've called the question on, I think.
That's correct. All right, is everybody straight? We're voting on the ought to pass motion made by Representative Moriarty and seconded by Senator Sanborn. And Supi, I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell.
Yes.
Representative Newell votes yes. Representative Harnett. Representative Harnett is absent. Representative Hagan. I saw him earlier. Representative Hagan is absent. 7 members voting in the affirmative, 5 members voting in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much, Supi. That closes the work session on LD 622. Just a quick check-in with committee members. Do we need a 5-minute break, or would everybody like to proceed?
Do we make a reference to what our ought not to pass was? Like an amendment or something, or is that?
With the no, the
Sorry.
people who voted no on the ought to pass.
Yeah.
Okay, so it doesn't
Hold
work.
on.
So for those who voted no, are you a straight ought not to pass?
I'm not.
I'm straight ought not to pass.
I'm not. I want the 17-year-old amendment with permission, just like the military. I don't think someone should go over and die overseas for their country and not be able to get married, you know. So my ought not to pass is the 17-year-old amendment with permission of the folks.
Okay, so your ought to pass as amended. Is there anybody else? Are there any other reports?
Thank you for clarifying that for me, Peggy.
So we have a 3-way split, ought to pass as amended, and then ought not to pass. Okay,
Yeah.
thank you.
Thank you. And Representative Evangelos, thank you for, I should have reviewed that. Thank you for bringing it up.
No, it's everything's so confusing around these things. So I've been here 7 years and I still have to get refreshers. So no problem.
Thanks. Let's take a 5-minute break and return at 3:20. Is that okay with everybody?
Yes.
Thank you.
It's not a caucus break, right?
It's not a caucus break.
Right.
It is just a
Bathroom break.
5-minute, quick 5-minute break. Thanks, everyone.
I'll be back in a bit. I have only 5 minutes.
that's awesome.
Hi, committee members. If you are present in the meeting, you can go ahead, please, and activate your video so that we can see who's here and ready to get started again. All right, it looks like we're back in business, so to speak. And the next bill that we have scheduled for a work session is LD 563, resolve to create the Criminal Records Review Committee, was presented by Representative Talbot Ross, and I believe that Peggy has an analysis to present to us, as she has with all of these bills. Peggy, whenever you're ready, we are all ears.
All right, thank you. So this bill is also a resolve, and you use a resolve when you're not putting something into the codified statutes. This creates, it's called the Criminal Records Review Committee, I believe, as written. It has 25 members, and it's a we could read through them all, but it's a lot of people to, the idea is to cover all the stakeholders to look at how to deal with criminal records, whether they should be sealed, the vacating of convictions, expunged. We have, Maine has a kind of a more stringent separation of powers interpretation of our Constitution. So expunging a record really is like a pardon. So in any way, this review committee would look at all these different issues about how to deal with criminal records. There's definitely a trend in the states to kind of allowing a clean slate or letting somebody's past convictions be either sealed or expunged so they can go forward with education and jobs. This advisory committee, this review committee would look at all these options, look at what the other states are doing. Some states have automatic sealing after a certain amount of time. And it's specifically, one of the issues that keeps coming up is now that there's adult use marijuana where you can possess marijuana. What about those convictions or adjudication, since a usable amount was a civil violation before? What do you do with those records? So those are some of the things that this review committee is going to look at, and make some recommendations going forward to this committee about any kind of legislation for the second regular session. The sponsor, Representative Talbot Ross, is trying to make sure that it doesn't take legislative money. So outside funding would be used. And she proposed an amendment at the public hearing to include 2 more members. One would be a representative of a public access advocacy organization. And the other would be, I'm sorry, Representative Harnet's not here, the chair of the Right to Know Advisory Committee, or the chair's designee. You had asked some information about, this is kind of a continuation of a group that it was initially identified in statute, and then it did not get funded, and the people in the group met anyway and made recommendations that ended up being, LD 776 last year. And Representative Talbot Ross has reintroduced that this year. It's her LR 1340, not that you would find that anyplace because you won't find it till it's printed. But I circulated the list, and Representative Thorne didn't get it because his name wasn't on the Judiciary Committee list, of the stakeholders in that group that have been going on. I've asked them to fix it, and I think I have, they just fixed it. So from now on, so there was a list of the stakeholders. I emailed that and I posted it in the portal. So if you have questions, let me know.
Peggy, can I just ask a quick question? And Representative Evangelos, I know you have your hand raised, but I just wanted to know, a public access organization, does that mean a member of the media?
It could be the media. A particular organization is like the Freedom of Information Coalition, of which Judy Meyer is the president, that has people who are members, like the League of Women Voters are members of that organization. So that would fill that requirement of a public access advocacy organization. But I assume that the Maine Press Association would also meet that requirement, and that would be up to the amendment allows the or directs the Speaker of the House to make that appointment.
Thank you very much. And I'm sorry to jump in the queue ahead of you, Representative Evangelos. Go ahead.
No, thank you, Madam Chair. Along the same lines, I don't think we should leave it up to supposition revolving around the Maine Press. I think there needs to be a specific reference to the Maine Press Association having a member. Because, for instance, if the organization Peggy just referenced named the League of Women Voters, then the Maine Press Association doesn't have a member, and I'm not taking a position one way or the other on that piece of it, other than that they have expressed serious reservations when we've taken these type of topics up before. They need to have standing here with everyone else. So I'm happy to make a motion ought to pass as amended, as suggested by Representative Talbot Ross, but with the addition of a specific mention of the Maine Press Association having a member as well.
And that would be in the place of the public access
No,
advocacy.
not in the place of it.
Oh,
Well,
in addition to?
yes, please.
Okay.
Thank you for your motion, Representative Evangelos. Is there a second? And again, just a clarification, Representative Thorne, are you raising your hand to second or for a different purpose? Not
Every
to
time I raise my hand, Madam Chair, it seems to be right in the middle of a motion. So
You're next.
mine is just a point. Mine's just a point of clarity as to the reporting out of the bill to the committee.
Just a moment then. Let's get the second down. Representative Babbage, your hand is raised. Also not a second. Okay, I'm turning to the committee. Is there a second on Representative Evangelos' motion?
Second.
Seconded by Representative Reckitt. Now committee discussion and questions. Representative Thorne, you have the virtual floor.
Thank you, Madam Chair. Mine has to do with the summary, and please feel free to correct me if this is a question that's better asked out of committee, but where it says we'll report to the Joint Standing Committee on Judiciary by December 3rd, 2021 with findings and recommendations, where I understand we won't be in session then. Is that something that will be held until we're back in session and meeting in committee?
You'll be getting emails straight through November 2022. Even though we're not in session, we still receive reports and do other committee related and other legislative work. So does that help clarify?
It does. It just means we won't be discussing it until we're back meeting in committee, correct?
Yes.
Thank you.
Yeah, thanks. That's a good point to raise. Representative Babbage?
Thank you, Madam Chair. I appreciate Representative Evangelos' motion. I personally don't think it's enough. I realize that we already have this gigantic group, and actually, I'm sorry, I haven't looked at. I've got 20 members, but I will. My concern is the last time I counted, we had 18 members of advocacy groups. We had 6 members of law enforcement, and House and Senate appointments. This is the original bill. But if we're talking about records, public records, then we ought to have some public records advocates that at least could make the argument. And I don't think 1 or 2 people is enough. I think there should be, like for instance, on the Right to Know Committee, a member of the Right to Know Committee could be anyone, because we have everyone from state police and attorney general and, all the way down to, we have the press, but we also have a public advocates organization, a transparency organization. I think it's good. You could look at the Right to Know membership. I don't have it at my fingertips, but I think it's good to have a transparency organization as part of this. I think it's good to have the Maine Press Association. I think it's good to have a member of broadcast media. Those are 3, not even counting Right to Know, which could be on either side of the spectrum, that I think would be good just to have as part of the discussion, so that multiple ideas are heard. That's all I'm saying. I think we want to have some confidence that all the transparency versus privacy is discussed in full.
Thank you, Representative Babbage. Can you just clarify for me? Can you please list who you're advocating be added to the committee who's not on there either in the bill or the motion to ought to pass as amended that Representative Evangelos made? I just lost track of
I
where-
think you mentioned that Representative Talbot Ross advocated for a public access advocacy group. And
as well as the Right to Know Advisory Committee.
and a right to know, which is not partisan. I mean, the Right to Know Advisory Committee carves out privacy protections from the public's right to know after a discussion of what's appropriate with all stakeholders present. Do you see what I'm saying? So
I do.
So the right to know has a mission to protect the people's right to know.
I'm just asking you for the list.
The other two that I haven't seen on there would be a member of the print media and a member of the broadcast media.
Thanks. I hadn't been tracking what you were saying, and that's really helpful. Thanks. Representative Evangelos and then Representative Moriarty.
Thank you, Madam Chair. Those are all good ideas, Representative Babbage. I'll amend my motion to include the Maine Press Association, the Maine Broadcasting Association, a Public Access Advocate, and the Right to Know group.
Thank you. I appreciate that.
Including, I'll do it if you'll second it.
Do you want to ask the original second, Representative Reckitt, or is?
Right up.
Fine.
And okay, so the second is there. That's great.
Oh, yeah.
Okay.
I'll ask Representative Reckitt to second. I'm sorry, I was horsing around, sorry.
No, I just want to keep everything clear for the record here.
Well,
Thank
Chris made some good suggestions, and I want them in the bill.
Yep. Great. Let's see, Representative Moriarty, I think you're next.
Yes, I think so. Thank you, Madam Chair. We do have a time problem with the bill as drafted. First, the committee has now grown from 25 to, I guess, 29 members. But according to Section 4, the members of the committee or people cannot be appointed until 30 days following the effective date. So hypothetically, if the bill is passed and signed, it takes effect 90 days from adjournment in June, becomes effective in late September. Members are appointed in late October, and yet we have a December 3rd, 2021 report date, some 5, maybe 6 weeks later. The report date, I think, is the reason for it is clear. It is that the 130th and second session can take up the substance of the report and not pass this along to the 131st. But as a practical matter, I find it hard to believe that a committee of this size, or even of half the size, could really address all of these issues in a 5 to 6 week period.
So I think there are two options. One could be to push back the report back date a little bit, or to add an emergency clause to the legislation. And Representative Evangelos, you have your hand raised. You can go ahead.
Thank you. Actually, if we adjourn in June, that would be September, so it's almost a 90-day window, but why don't we push it back to January 3rd, 2021 and give them an extra month. I'll add that to my, I don't know how many times we're going to do this, but it's, point well taken. A lot of people to get together, they got to issue a report and all that. So that would get it up to almost 4 months. So I'm just going to amend my motion to include Representative Moriarty's idea. Let's extend it out an extra month.
And Representative Reckitt, as the seconder, or do you approve of that amendment?
Yes and no. I'd rather someone else seconded.
Okay. Do we have a second? Representative Babbage?
May I comment, Madam Chair?
Yes.
Oh, I understand people, and I'm sorry. I just wanted to say that the staffing of this group would be available to my understanding, only when we're not in session. That's really the window that we have in order to get the work done. So I think January 3rd is fine, but probably they'll try to get it done by December so that it can be finalized prior to the session anyway. Cloture will be happening in December, so.
Thank you. Thanks. Peggy, you wanted to speak with us?
I was going to mention that, and I was going to mention that there's a joint rule that applies to studies, which says studies in that end in the first year of a regular session, so they're reporting to a second year of a regular session, need to wrap up in December, the beginning of December. So that would be right. And that may be the better way. I mean, I realize it takes a 2/3 vote to put an emergency on it, but that might be the better way to give you more time. Representative, I don't remember who said it, Representative Moriarty, Representative Babbage mentioned that staff assistant specifically says that legislative council staff support is not authorized when the legislature is in regular or special session. So I guess there are two ways to do that. And what happens with studies that are not in conformance with the joint rule is sometimes they get amended on the study table to be in conformance. So even if you pushed it out a month, you might lose that in the approval of the study.
Thank you. Both you and Representative Babbage, you've helped us shape this legislation more solidly. Representative Evangelos?
Back to December 3rd, and going to be in compliance, and everything else stands regarding the 4 groups we added. So we already had that motion. I'm just withdrawing the extension of the date. But Lois did second it without the date extension. So, so I think we're good to go.
Thank you,
Want
Representative.
me to restate it, or want to start over, or are we good?
Did you just change it to an emergency?
No, I'm not going for the emergency. I don't
Okay.
want to complicate it. Just straight majority vote, but December 3rd, as it stated. I want to follow the rules. I don't want to follow it up because we didn't. So we're adding the 4 groups that were suggested by Representative Babbage, and I tried to accommodate Representative Moriarty, but the rules say we can't. So you know how this stuff goes, Peggy. There'll be flexibility, when they're working anyways. So. Thanks.
Thank you, Representative Evangelos. Go ahead, Representative Reckitt.
Well, I'm not willing to second it with that, without the emergency provision, because I don't believe it's possible. So I withdraw my second, and someone else is welcome to do it.
All righty. And Representative Babbage is the second on the motion ought to pass as amended. And I believe that Representative Moriarty and then Senator Keim were the next in line to speak. Go ahead, Representative Moriarty.
Thank you, Madam Chair. I mentioned the adjournment date for the reason that, again, on the second page, section 4, it provides that appointments to the committee can't be made until the effective date of the resolve, not opposed to the date of adjournment. So we are, in fact, talking about the earliest possible start date being in mid to late September, assuming that we adhere to the typical adjournment timetable.
Yeah, noted. And Representative Evangelos, who made the motion, has decided against adding the emergency preamble at this point.
Madam Chair, I'm not sure we're going to get 2/3 vote on the floor, so I don't want to take the risk. So.
Let's hear from Senator Keim, and then I want to welcome the bill sponsor as well. But you go ahead, Senator Keim.
Thank you. So I'm concerned with a number of things here. I think what stands out to me strongly is that it's a very large group of people, and yet the balance I don't feel is there. There's a lot of folks who are advocates, for a select interest, but one of the voices that's really not being heard here is that of victims, and crimes have victims, and I think that's a glaring omission here. I also think the group is too unwieldy. Even as I say that, there's just it's going to be difficult to find a time where all these people can get together, and so then the people that do choose to join in have an outweighed voice on what comes back to the legislature, under their name, seeming like it's a more balanced report than maybe it can possibly be, just for the logistical reasons of it being so difficult in a very short time to deal with issues that have such, that are actually really technical. And that's my other issue here, is that what has been stated, it's not as if we can wave a magic wand and make the convictions and the adjudications disappear. There's a lot of technical work that needs to be done. And I think I like the idea of having some review. I just think that what really needs to happen first is for there to be just some really technical discussions about how this happens, how it actually physically can happen, and capturing all the different locations where this data is held. And then the idea that the advocates and the people that have a special interest, then they come in behind and create policy decisions, whereas this is trying to tie them all up in one, which is, I think, part of the problem here. It's trying to say, well, everyone needs a seat at the table, when actually, when it comes down to the policy, I think that happens in the legislature. We decide what the policy is, and all of these people would then be welcome to come testify. But the technical aspects are really not, I think, well thought out with the group here, and the focus is not strong enough on those technical aspects. I think there needs to be more input from like state police and SBI. And for those reasons, I will be voting not to pass on this bill.
Thank you, Senator Keim. Welcome, Representative Talbot Ross. I don't know how much of our earlier conversation you heard, but we're delighted to see you in the Judiciary Committee, and we have pending before us a motion ought to pass as amended. And I'm just going to ask Peggy if she could please recite for us the amendment that we are currently discussing, so that we're all on the same page here.
I think the amendment is what Representative Talbot Ross had offered at the public hearing, plus 2 more representatives, one from the Maine Press Association and one from the Maine Broadcasting Association. And I think that's all the changes you've done. You've talked about, right. You talked about moving the date and decided not to move the date, and talked about an emergency and did not add an emergency.
Yes, that is where we are. Thank you very much, Peggy. Did you want to address the committee, Representative Talbot Ross?
Thank you, Madam Chair. Just a point of clarification so that the committee has it. The DPS designee in the last 2 years that we've been meeting has been Matt Burrell from SBI. And so that is, SBI has been part of the process since there has been a process. And to the training and the education on the technical matters for the representatives of organizations not tied to the state. I think they were called advocacy organizations. SBI does do a presentation so that everyone does understand the roadmap for sealing records. And the representatives of these organizations are not just interested parties, but these are folks who have lived experience. So I really want to make sure that we understand the lived experience component, and that there is membership from victim organizations on the commission. And you heard from two of them during the public hearing about how balanced the process was and how organized the process was, and that they were happy with the end result, which did produce a bill, and it got carried over because of COVID. We are bringing that bill back. So there was a work product that 25 people were able to come up with in a very short period of time. Scheduling everyone was not an issue the last 2 years we've been doing this. And while I appreciate you wanting to move the date to give us more time, there are many members of this committee who are already willing to get together before the bill passes in order to then get to work right away and be able to bring back to this committee a report, a comprehensive report that you can consider. This is work that doesn't have a start date and a stop date. This is work when we're talking about sealing records or considering sealing records. This is work that is fluid, that needs to go on in order to think about this. So we're very committed to the process. And I think by virtue of the fact that folks keep saying that the size of the group is unwielding, but then we keep adding more people, shows that this is a necessary exercise. And I appreciate you listening to me today. And I also appreciate all the consideration, whether you support the bill or not, that's gone into this process. So thank you.
Thank you very much, Representative Talbot Ross. I see a number of committee members' hands up, and I believe Representative Libby that you were the first hand up.
Thank you, Madam Chair, and thank you for being here today, Representative Talbot Ross. My question pertains to the schedule. We've been hearing a lot about emergency or not having it as an emergency. And I guess my question is just to clarify, since we're having the work session today, would this bill be coming to the floor during the Democrat majority budget session next week, or would that be at a later session?
Representative, you're
no.
not asking me, right? Okay, thank
I'll
you.
answer it. Representative Libby, what we've seen in the past is that typically it takes a little bit of time for bills to move from committee onto the floor of the House and Senate. And so just based on how things went when we last convened for the supplemental budget, I think that probably this there's not enough time for this to be ready for our meetings next week.
Thank you.
And Representative Hagan, I think you're next.
Thank you very much, Madam Chair. Sorry, I have a thing called dry eye and my eyes are burning and I had to put my medicine in. So that's why I mute my face. So I do that off. I don't horrify you guys. So anyway, I would like to comment that I would agree with Senator Keim on all of the things that she had to say. I've been thinking about this one a lot. And I have I'm wrestling with all of the concepts of what this bill is resolve is all about, and I don't feel comfortable voting for it. So I'm going to go against it at this point of the stage of the game, as it were, for those reasons that I won't repeat her monologue and whatnot. But I'm just uncomfortable with all of this, still wrangling with the sealing and expunging and varying things. So for me, I'm going to vote no on this today.
Thank you, Representative Hagan. Representative Thorne?
Thank you, Madam Chair. I'm in hopes of being able to vote in favor of a bill today. So please indulge me as a new member. I've tried to get caught up and up to speed. And I realize that I've missed the public hearing section of these bills, and our work session is my chance to get the essence of them I listened to most of the committee members discuss it, and that's very helpful to me. So I'm glad that you have your open and frank discussions. Looking at this one, and looking at the duties resolved of the committee members, I see it as more of a glorified parole board for records, and the disposition of those, and whether or not any should be changed or who should get access to them. And I'm trying to understand what the current laws are as it pertains to records, and whether they're sealed or expunged based on typically, and maybe Representative Moriarty could clarify, because I think he may know, is there a typical timeline that these records normally go through this process? Or are we trying to get a committee to look at them one by one and either expedite that process or delay that process? And that's what I'm getting when I read it through, and maybe somebody could clarify for me so I could make an educated vote. Thank you.
You're in a tough spot, Representative Thorne, because you're new to the committee and you missed the public hearing on this, and it is complex. It's sort of like a law school class to really wrestle with all of this stuff. And maybe I see that Representative Moriarty has his hand up, but I also know that Peggy, our analyst, has been addressing these issues for 30 plus years as the analyst for the Judiciary Committee. And Peggy, could you take just an initial step toward explaining to Representative Thorne kind of where we are, and then we'll see how to proceed at that point?
Sure. I'll try to do it quickly. So the Criminal History Record Information Act provides that things like conviction data, that kind of information, is a public record for everybody going forward. That does not include juvenile records. So any criminal conviction stays on the record, and you can get it from SBI, or if it's a Fish and Wildlife violation, you go to IFNW. If it's marine resources, you go to the marine resources. Those are all public records. And that's what the SBI maintains. It's the State Bureau of Identification. The court also has records. And so if you were looking for the adjudications, the civil adjudications of marijuana possession, the SBI does not keep those. So you would have to actually go to the court and look for those individual records. Whatever you do with the records in SBI is not touching the records that are in the judicial branch. The courts have all those conviction records as well. So I think I understand what Senator Keim was saying about you need to figure out where all these records are, and then you need to decide what you can do with them before you decide how you're going to go forward. So right now in Maine, a criminal conviction is a public record, is a public record, is a public record. I think they might be wiped out when there's a pardon, but pardons are few and far between. So I think I don't know if I left anything out, but I think that's what we're looking at really is convictions wherever they're held.
And that's what I'm looking for in this resolve is what it directs the committee to do, recommend whether or not they get expunged or
sealed. We had a process where a very minor Class E crimes. If you had one Class E conviction, you could go to the court and ask for it to be sealed after, if you were under 25 when you committed the crime, and you had a clean record for a few years after that. You could go to the court and have that individual record sealed.
All right, and that's what this is saying, is this committee could ask for exceptions to existing laws and to have us decide whether or not that they were to be followed out or whether the law would apply as it
Right.
stands.
So
Okay.
some states, and actually Representative Talbot Ross knows this so much better than I do. Some states, after a certain amount of time, they seal up, they expunge the record. We don't have that for any type of conviction, or they give you the option of having it sealed, and then the person with the record has to go through a process to get it sealed. Right now, we don't have any of that on the books. The work product from this working group has a bill that's coming forward to reinstate the sealing process. But other than that, main records are public records.
All right, thank you. That helps. Thank you, Peggy.
Thank you, Peggy. Representative Hagan?
Thank you, Madam Chair. I'm wondering if Matthew Rule would be in the other gallery and available to discuss some of his thoughts on the testimony that he gave.
Can you remind us again who he is?
Matt Ruel is the director of the State Bureau of Identification.
Thank you very much. Would committee members like to hear from him? Yes, it looks like the answer is yes. I'll move him in. Thank you, Supi, for moving Mr. Rule in.
I think I'm in. If everybody can see me and hear me.
We can.
All right, good afternoon, everybody. Thanks for having me. Thanks for giving me a reason to put a tie on for the first time in many months. So I don't know if you've got a specific question, Representative, or if, I mean, I can talk. There's no problem there. I could just start spouting off things, but I'm guessing you probably have time limits, and so I'll throw it to you.
Let's ask Representative Hagan, since he requested that you join the panel. Representative Hagan.
I was compelled by, thank you very much, Madam Chair. I apologize, I just interrupted you. I'm sorry about that. I was looking at your testimony, and I think I was not present during the actual hearing, and a lot of your testimony I found interesting, and I thought I would like to hear a little bit more on it. And having not been in I don't remember, but where I'm at school all day long until 2:30 or so, I miss a lot of the public hearings. I try to watch them on YouTube, but sometimes life gets away from me. So I was interested in hearing from you a little more detail on some of the thoughts that you had on this particular resolve. Or
Sure.
Yeah.
So I guess, just to start with this, I have been working with Representative Talbot Ross now for a couple of years on this. I've been at SBI for going on, I think, 17 years. So I deal with all the criminal history records. And I think somebody mentioned it earlier, and I think it really is very true. This is a really complex topic. Having a study group to kind of look at this stuff gives folks a chance to look at all the different sides. Whether you're talking about the law enforcement perspective and DA's access to information, the public's right to information, criminal justice reform is such a big topic nationwide right now, and how do you incorporate that in? There's a lot of misconceptions about how records are either sealed or expunged. A lot of people use that terminology really they mean this, they'll say that they're the same thing, but really they're very different. So I think just being able to explain some of that stuff to the group and how our process works is important. And I'm happy to kind of participate and share some of the things that I see as potential roadblocks, or at least things to consider. A lot of folks don't understand that we've got state requirements, federal requirements. There's probably a financial piece to this that people may be concerned with. The press has things that they're interested in. So I just try to throw that stuff out as the person who deals with it day in, day out for years now. There's a lot of state agencies that need criminal history records and background checks just as positions of trust that they're kind of vetting for licensing and certification. So they've got a different set of rules that they look at. Gun checks, NICS requirements, those have all different kind of federal statutes tied to those. So I just tried to raise those as issues and kind of bring that perspective to the group.
And Mr. Rule, I just want, so do you think that this legislation, this resolve to create the Criminal Records Review Committee is a good recommendation?
Boy, that's always a tough question when you ask what my opinion is, because my opinion is really what the administration tells me my opinion is. But honestly, I can say that I think anytime I have an opportunity to sit down with people who have an open mind and sit around the table and talk about some of this stuff and dig into it, how do you lose in that situation? I think that's worthwhile. And I'd be lying if I said otherwise, because I personally think, all these ceiling bills that are going to probably be before your committee this session are so complex, kind of rolling them all into this study group will give them a little bit better vetting before votes are made. That would be my opinion.
Thank you very much for sharing your opinion with us. We really
Sure.
Committee members, are there additional questions for Mr. Rule? Not seeing any. Am I mispronouncing your name?
After this many years, I've grown accustomed to people saying Rule, but really it's Ruel. But I'll answer to just about anything.
Okay, thank you, Mr.
But thank
Rule.
you for asking.
Committee members, are no more questions for Mr. Ruel. Thank you very much for appearing before the committee today for our work session.
No problem. Take care and be safe.
Thanks. Representative Evangelos?
Thank you, Madam Chair. Very briefly, I just wanted to, because he did miss out on some of the aspects of this, to Representative Thorne. One of the concerns is that we've had people's lives destroyed with marijuana convictions, and now people are out making $1 zillion on it. And, it's simply unfair for that piece of it to be out there. Similarly, along the lines of what happened in the 1930s with Prohibition, in the 20s and 30s, then liquor became legal again. So we don't want people's lives destroyed. They can't find jobs. It goes right down the line in their whole lives. So that was part of the discussion. I just wanted you to know that. Thank you.
That's really helpful context. Thanks, Representative Evangelos. Peggy, thank you for raising your hand. Go ahead.
Thank you. And actually, Mr. Ruel mentioned that you have ceiling bills coming. You heard one of them the same day we heard this bill about marijuana adjudications. You have several more that are coming. And the idea was maybe if you could have some kind of central review of all these different things and try to figure out the best way to go forward, you could carry over those bills and then you'd be ready to address all of them in January, because you would have sent this group off to do its work, to examine what's going on in other states and come back with recommendations. So we scheduled this bill to be worked first before you get into all those other ceiling, expungement, vacating bills that are coming your way.
Representative Talbot Ross?
Thank you, Madam Chair, for the opportunity to add a comment. Again, I just wanted to also add for Representative Thorne's knowledge that this is a bill that brings back options. This isn't the bill that seals all records. This isn't a bill that says we're going to expunge all records. This is a bill that says a group of people who have some lived experience and expertise, which is led by the Attorney General's Office, DHHS, Department of Corrections, Department of Public Safety. Matt's work is extraordinary on a committee like this, because he's really able to cut through some of the ideas that the committee comes up with. He'll say, nope, you're touching 4 different systems. It doesn't work. We've worked really well together. All of this does is ask a group of people to study that issue, to look at the options, and then come back and give you the power of understanding what those options look like. This is not a bill that's sealing all records or moving parole forward or expunging records or pardoning records. It's giving options for consideration. And I just want to make sure that that is well expressed. And the fact that I gives me an opportunity to appreciate Matt's work in this area. He's a dedicated public servant, so just gives me the opportunity to say that. Thank you.
Thank you, Representative Talbot Ross. Peggy, did you have your hand?
Oh, no, I'm so sorry.
No, I didn't want you to think I was ignoring you.
No.
Yeah, and just to follow up on what Representative Talbot Ross and Peggy said, we do have a number of these bills. They are very complex. Getting this committee's recommendations and analysis of the way all of the different statutes that create confidentiality of records interact, that will really assist our committee's work in the future. Committee members, are there other questions or comments on this legislation? Not seeing any hands raised. Is the committee ready for the vote on the ought to pass as amended motion? Looks like we are, and I'll just move Mr. Ruel and out of the panel. Representative Talbot Ross, you can stay since you're the bill sponsor. And all right, so the pending motion is ought to pass as amended on LD 563. The amendments include adding to the committee 4 additional members, the Public Access Organization, a member of the Right to Know Advisory Commission, a member of the Maine Press Association, and a member of the Maine Broadcast Association. I'm looking at the committee members, and it looks like that is everybody's on board, that is the pending motion. And so Supi, thank you very much for taking the vote.
You, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
No.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Keim. Senator Keim is absent. Representative Harnett. Representative Harnett is absent. Eight members voting in the affirmative, 4 members voting in the negative, 2 members are absent. That is the vote of the committee.
Thank you very much. And that concludes our work session. Oh, before I move on, could the no votes please let us know what your report is?
No.
Is it
Just
great not to
Not to pass.
Yeah.
Thank you. Thank you very much for joining us, Representative Talbot Ross.
Thank you all.
We do have 2 more bills to do work sessions on, but we also have an important conversation that Representative Evangelos requested that we have related to our work on the budget initiatives related to the Maine Committee for Indigent Legal Services. And I would like to restrict our conversation to that topic. Representative Evangelos actually had a 4 o'clock stop today, and I want to respect and apologize first for running over, respect your timeframes. But if we can focus on the issue of whether and how the committee can continue to address and advocate for the budget initiatives, that would be very helpful. And I'm going to give you the floor, Representative Evangelos.
Thank you, Madam Chair. And it certainly was no one's fault that we ran over. I think you only have 1 bill left, so that's good news for the committee. Not 2. So
we have 1 other that we're going to re-refer.
I'll be as brief as possible. Senator Sanborn was nice enough to send me an email that explained what's going to come down the road going forward. Obviously, my worry is that we invested a lot of time last year and this year in adopting reforms to make sure that our indigent defendants can get the legal counsel that's guaranteed them under the Constitution. And, I'm really worried about next week. It's one thing to say you have the votes and the Democrats are doing it because they can, but I'm worried about the future of our process and the goodwill that we've always operated under here. There's some rough spots. It's going to happen in politics, but in the end of the day, I'm friends with everybody when I leave here, but it's going to get really corrosive after Tuesday. It's human nature. I'm worried about it. So I'm worried about the ability of supplemental budgets to take care of the needs of the indigent legal defense and other items that are going to come up. I know the Criminal Justice Committee is engaged in a similar battle. They want their budget, not this budget that's being, I'm sorry, forced on us next Tuesday. I don't vote with the Republicans very often. This is not an ideological dispute. This is a fairness issue with me, Senator Carney. It's just simply a fairness issue. I wouldn't treat people like this way if I was in charge, because I would realize that someday I'm not going to be in charge and I want them to respect me then. What goes around comes around. That's what we used to say in the 60s. And so I have legitimate worries and concerns, not only around the funding, but around the process that we're going to be facing. There's going to be a lot of people mad next week, and I don't blame them. I've said enough. That's what I wanted to get off my chest. I'm worried about the funding. I'm worried about a variety of funding issues, not just our committee, but certainly around indigent legal. The optics of this isn't going to look good to people like Robert Cummins and David Carroll. So I am legitimately concerned and worried that the goodwill that we generally operate with around here is going to be destroyed. The last time this happened was in 2011, and it was a very small supplemental budget. And Governor LePage had the Republicans ram it through on a majority vote, caused a lot of bad will then. But we've never done a whole budget like this. I don't believe. Bangor Daily News, they researched it and couldn't find it was done in the last 50 years. So that's it.
Thank you.
Thank you for hearing me out on that.
Yeah, I would just like to respond. I appreciate that you are focusing on goodwill and your concerns about goodwill. And I think that I know that when we worked on all of our budget work, but particularly with regard to the indigent legal services, we did as a committee really rely on all of the homework that we had done leading up to those budget votes. And we worked really hard and effectively together. And we generated a lot of goodwill among the committee members. And I think that we really spoke powerfully and impressed the Appropriations Committee. And our opportunity to continue to advocate for those budget initiatives has not changed at all. And I am very committed to continuing to advocate for them. And I think we should all continue to advocate for those budget initiatives. We know as the policy committee that the work that we did is really crucial to ensuring that the Sixth Amendment is complied with in our state. I don't see the work that we're going to do next week as impinging actually on our work on indigent legal services funding. I think that it is designed to really reassure Mainers that that we're moving forward. And I don't want to get into it because we're really talking about what's within the jurisdiction of us as a committee, which is the indigent legal services. And I think that we should continue to all hang together on that and continue as a group to advocate for those initiatives. I think I've said enough. Senator Sanborn, you can proceed, and other committee members, please raise your hand if you'd like to contribute.
I don't have anything really to add. I just wanted to focus on the Mickles issue as well, and just say that I think our opportunity to continue to advocate and perhaps even have a better procedural posture for advocating for MCLS, since there will be a new proposal for additional spending. We get another shot all the way back at the beginning. And I actually think that that could enhance our opportunity to advocate, given that we entirely rewrote this section of the budget and did so quite persuasively and with quite a bipartisan voice as to a number of initiatives. And so I actually think that with regard to MCLS funding, we're in a better procedural posture by having the baseline not tied to the additional spending. So that's what I would just say. And I, again, just wanting to focus entirely on the MCLS piece as we're in the Judiciary Committee.
Thanks, Senator Sanborn. Senator Keim, I see your hand, but not you. There you are. Go ahead, you can proceed.
Sorry, I should have warned you I have to head out to the bank so I can have new bank accounts. And that's what I'm doing. But I appreciate the conversation and having one. I too am very concerned about the process. I think that we all work together in committee in good faith. And yet next week, the vote, and we worked on MCILS, I thought, in good faith. And yet over the weekend, things changed drastically. And for every Democrat, everyone that votes for this budget
Senator
is really
Keim, I just
terminating
interrupt you.
our
He's really talking about the things that are within our control as the Judicial Committee and the MCILS budget, and not debating the debates that we're going to have next week.
Absolutely. And our process together is definitely hurt by that decision, because if we work together, it's thought that that consideration is given for everyone's voice, and terminating some voices from the process doesn't help us in the future to work together well, either on this MCILS budget or any of our other issues. Thank you.
Yeah, thank you. And I would just say that we should all continue to work together on this issue. It's an imperative. We made such great progress, and I as Senator Sanborn said, we are in a good position to continue to work and toward implementation of those initiatives that we know are so important and that we all worked so hard to present effectively to the Appropriations Committee. Representative Hagan?
Thank you, Madam Chair. My wife just walked in. She's loud and I couldn't hear you, so loud with the stuff she bought. I would also agree. I would like to agree with Representative Evangelos and Representative Keim. I'm nervous about what's coming ahead for us. And I love our collegiality on this committee. One thing I miss is the in-person stuff, and I feel like every person on this committee is like the nicest person in the land. I look forward to working hard together to try to get things taken care of, but I am quite nervous about events that are coming our way. And that's all I have. Thank you.
Yeah, thank you. I agree with you 100% about collegiality, and let's keep sticking together on this issue that we worked so well on. Go ahead, Representative Libby.
Thank you. I have the same concerns as my Republican counterparts for good reason, I think. And I would like to ask, Representative Evangelos referenced an email from Senator Sanborn, and I would appreciate if Senator Sanborn is willing to share that information with me as well. Being new to this process and having such a different process ongoing at the moment, it's hard for me to fathom how we can continue a conversation when so much of the funding after this is going to be one-time funding. I'm not sure how that helps MCILS, but I will attempt to keep an open mind.
Go ahead, Senator Sanborn.
Yeah, I think the substance of what I shared with Representative Evangelos is really what I already said, which is that I think there will be an opportunity at this point. I think that the plan that the governor has conveyed publicly, I think at this point, is that she would propose another supplemental budget as opposed to a change package on the original budget that she proposed. And so that it would be a supplemental budget that would be proposed. So that's, I think, all I had passed along to Representative Evangelos, and that I had hoped that perhaps in this second round effort of putting together a supplemental to cover any non-baseline spending, any spending kind of that isn't covered in our back to basics budget, that the governor would have another shot at actually addressing this committee's concerns about her lack of proposals above the baseline in her original budget. So that's the only substance of it, and just had passed that information along to Representative Evangelos, because I wasn't sure, as he's in the independent caucus, whether he had heard directly from the governor that her intention was to put together a supplemental budget, and that was her intention as to how to proceed. So happy to share that with everyone as well.
Thank you. I think I don't remember whose hand was up first, Representative Thorne or Evangelos, but whoever was first, please unmute and speak.
Thank you. I'll be brief. Representative Evangelos, and perhaps in my question, you may be able to answer it. Where I'm a freshman legislator, I need to ask you this because I'm not sure of the process, where we talk about a judiciary portion of the budget, and whereas my understanding is that the budget that we're voting on next week will be strictly a Democrat built budget. And then I hear talk of a supplemental budget. Well, will both parties have a say in our portion, the judiciary, of the supplemental budget? Or will that supplemental budget also be determined by the Democrats and or the governor alone? Or will we have a say in that? If somebody could help me on that.
He asked me, so I'll answer it. First of all, in Representative Libby's question, Senator Sanborn just sent me a nice courtesy email because I think she's picked up my vibes that I'm not happy about this situation, and wanted to assure me that indigent legal was still on the table going forward, and because she knows how much I care about that. And that was the substance of the email. Representative Thorne, to answer your question, nobody knows what's going to happen after next Tuesday, because part of the question you're referencing is how are people going to be treating each other after that date? And that's something, we're all talking about it. We're concerned about it. But I mean, normally the supplemental budget process would go through the Appropriations Committee. specifically to answer your question, the Judiciary Committee a couple of weeks ago, I believe unanimously rejected the governor's budget on the indigent legal portion of it. We went into the Appropriations Committee and submitted our own budget, which delineated a lot of the reforms we're committed to. Those reforms are not in this budget. So we're back to the governor's baseline budget on Tuesday. What happens after Tuesday? Your guess is as good as mine. You don't have to be here a long time. You got elected, so you know how it works. We'll see what happens. There's a process. The process calls for the involvement of all parties in the Appropriations Committee and the involvement of our committees, and we'll just see how it goes forward. I wish I could give you more on that, but I don't know what's going to happen.
May I ask one follow-up question, Madam Chair?
Layer on a little bit what Representative Evangelos said, because again, you're new to our committee. We're delighted you're here. I will send you so that you have the key documents that are related to the initiatives that we approved. I'll send you the memo from Indigent Legal Services and also a sheet that reflects the committee vote. And then please feel free to call me anytime. I'll include my cell phone number on there for you. And you can call me anytime that you have questions about it. I know that I'm sure, not speaking out of turn, Representative Evangelos would also be happy to give you as much information about that as you'd like.
Thank you, Madam Chair. May I ask one more question and then I'll be done?
Sure.
I'm curious, you mentioned that Senator Sanborn said that the indigent legal services is safe and it's on there. And I'm curious as to how she knows that, how she can say that.
I think that's
it's not in the approved budget.
So
let me
can I
answer the
clarify
question.
that?
She didn't say that. What she said was that that the idea of funding it isn't dead. It would come up in a supplemental budget. That's what she said.
Did you, Senator Sanborn, did you want to add anything to that?
Just that I will continue to advocate for it. Is sort of what I meant by that it was still alive, and that I thought this puts us in a potentially a better position to get the initiatives that this committee recommended included in the discussion going forward. And I guess I would just also comment that generally the process with any budget is that the governor proposes it, and then it goes to the policy committees, and then it goes to AFA, and then AFA figures out what to do and where to, how to vote on it.
So whether or not the entire legislature gets a chance to vote on it depends on the president and the speaker. Do I get that right?
That's not
No. So anything that's going to come to the floor of the House and Senate has to be approved by the AFA committee. And so the AFA committee would take a vote, and then it would go to a vote of the House and the Senate, just like any other bill. It's just a bill. The budget is a bill. And so that's the process. And I'm not speaking specifically to any particular, budget here, whether it's the one we passed 2 weeks ago or the one that we may pass next week or some future budget, but just that the way that a budget becomes a law is just the way any other bill becomes a law.
All right, thank you. And we'll hope for the best. Thank you.
Committee members, are there any other, looks like everybody, I don't see any hands. I think what we'll do is, I know Representative Evangelos that we've kept you a half hour beyond your time limit. So we'll say goodbye to you, Representative Evangelos, and we'll resume our work. Our next bill.
You got me in trouble with my wife, so you'll be happy about that.
Please apologize to her from every single member.
We're just doing our job. I'm only kidding you.
We can take a vote on the apology if you'd like.
No, I'll take the fall. Don't worry. I'm used to it. But thank you. It was a good session, and thank you for your kindness and understanding.
Yeah, thank you for your bringing it up. I'm glad we did that as well. Take care.
I appreciate it. Bye-bye.
Okay, committee members, we have two items before us. One is LD, I've got to put my reading glasses on, I think 535. And then also we have a re-reference on LD 913. And the bill sponsor for 535 thought he was going to be able to join us later, and I think that we have gone beyond his availability. So let's take up 535 and then we'll finish with the re-referral. And Peggy, would you like to take us through the bill analysis on 535? That's an act to provide the well-being of companion animals.
Yes, 535, an act to provide for the well-being of companion animals upon the dissolution of marriages. So this amends Title 19A in the divorce chapter and in the subchapter on property, how property is divided, because that's really the only place where I see Senator Chipman is here. So this would add a new subsection to section 953, which is disposition of property, to specifically require the court to consider well-being of the companion animal and all relevant factors, including but not limited to, and then there's a list of seven specific facts or information about the animal and its relationship with the couple that's splitting up. And it defines companion animal means an animal kept primarily for companionship rather than as a working animal, service animal, or farm animal kept for profit. And a couple of other 3 or 4 other states have adopted something in their statute that specifically identifies pets or companion animals as an idea that the court needs to look at in a divorce rather than treating them as any other type of property that could be owned by the marital couple. And you had lots of testimony, you had a lot of written testimony, and I know Senator Chipman is here. You had many people providing their own stories. And then you had the Maine Veterinary Medical Association and the Maine State Bar Association, the family law section, sorry, of the Maine State Bar Association submitting testimony against. And then you had a couple of people offering testimony neither for nor against. One of them was the judicial branch. And I think part of the concept that the judicial branch is putting forward is that the courts already have the discretion to do this. And adding it as written might add additional fact finding that the courts must enter into. We do not have a fiscal note for it. And I think that's all I need to tell you. You did get a couple of pieces of testimony since the hearing, but those were all in the portal.
Thank you very much, Peggy, and welcome, Senator Chipman. I know that your schedule was very busy today, and I'm glad it worked out that you could join us for the work session. I ordinarily ask committee members to speak first, but Senator Chipman, and then I'd like to make some comments or raise some questions about the proposal that with some suggestions for amendments. But Senator Chipman, you can go ahead if you'd like.
Great, thank you. I appreciate your time on this, and I know it's been a long day. I did want to just mention, I believe Representative Harnett's the lead co-sponsor on the bill, and he may appreciate being able to be here for this, although I know he's not here right now and we've lost a few members. And so I wanted to say that it might make sense to table the bill from that respect. I understand there's a lot of, we have quite a big workload as all the committees do, and we have timeframes and deadlines, but just would put that out there. And also wanted to mention that Robert Fisk is here from Maine Friends of Animals, who helped draft a lot of the language, looking at what they do in other states. And he's been in the waiting room and I believe is still there and available to answer questions about some of the technical aspects of this. And so I just wanted to mention that as well.
Thank you very much. I appreciate your suggestion of potentially tabling the bill. We actually have an incredible number of bills to work on, and we had a really robust public hearing on this bill, and I think we should try to move forward today on the bill. I would like to raise for the committee and actually get your reaction as well, Senator Chipman. I've been looking at this bill and looking at the way it's structured. It creates a standard called the well-being of the companion animal, and then lists factors. And some of the factors certainly have to do with the well-being of the animal, and others have to do with the well-being of the people. And to me, just when I think about how a judge might apply this statute, I wonder if it would be more consistent to have the well-being of the companion animal be one of the listed factors, so that the judge could, for example, prioritize if there was a child who had a very particular emotional dependence on the animal, that wouldn't be subsumed within the category of the well-being of the animal, but that there would be criteria that related both to the people and the animal in the situation. And so I put that out there, and I would love to hear your reaction, Senator Chipman, and also committee members. And if it helps people follow my train of thought by screen sharing, I can also screen share and show you what I was thinking.
Yeah, just in response, Senator Keim, Senator Carney, I would say that, yeah, I think that would make sense. Also would, I guess, ask if it's possible if you could get some response from Mr. Fisk, where he did help draft a lot of the language for this. And I think he's in the waiting room. I can't see if he is, but I believe he is.
He is. Committee members, would you like to hear from Mr. Fisk, or would you like to react to the amendment first? Not seeing a lot of, okay, raise your hand if you'd like to hear first from Mr. Fisk, or if you'd like to weigh in yourselves. Mr. Fisk? No? Okay, we've got, Representative Thorne would like to hear from Mr. Fisk, so we will move him in. Mr. Fisk, when you, thank you for joining us today. We can see you, and if you can unmute.
We good now?
Yes, and we appreciate you joining us. I wanted to let you know that the work session is different than a public hearing, in that we try to just focus on very narrowly on questions rather than having a full presentation of testimony. And so we'd like to hear your reaction to an amendment to the statute that would take that phrase, the well-being of the companion animal, and make it one of the factors, along with the other, I think it was 7 itemized factors, rather than having the well-being of the animal kind of be the umbrella with the 7 factors underneath of it.
Well, thank you. I've been here since 9:45 with you, and it's nice to see all the dog owners on the committee, and a shout out to Sophie. I'm not quite sure the idea behind your amendment. I mean, what is not clear in the language as it is now?
The way I read the statute now, it seems that the concept of the emotional attachment of a child in the household to an animal only gets taken into account so far as it relates to the well-being of the animal. And I'm just thinking about how a judge would apply the factors, and thinking that if a judge could consider the well-being of the child in the household who has an attachment to the companion animal on par with the well-being of the animal, it seems to me that those are equal factors to be considering, rather than the well-being of the emotional attachment of the child only being relevant if it related to the well-being of the animal.
Yes, the essence of it all, there is a bond between the child and the animal, and both are affected in it. And if that is the pleasure of the committee, I'm not a lawyer. I did help put this bill together, but if that works with the committee, I don't have any problem with it as I understand it.
Thank you. Representative Thorne, did you have specific, did you have a question for Mr. Fisk?
Well, and again, it's thank you, Madam Chair. I'm looking at this in the perspective that it's pretty basic, and it gets complicated because emotions, I know, come into play, much as they did when we were discussing the previous bill on under 18 marriages. So I think that if I understand the way that it's the intention or the essence of this bill is to allow, in the event that the two parties are unable to make a decision over, and I won't say custody of the pet, but is this in the event that the two parties are unable to come up with an agreement, or is it, okay.
Yeah, it's only if they can't agree.
Thank you.
Committee members are Representative Babbage.
Thank you, Madam Chair. I'm on, right? Yes. I'd like to make a motion, if I may. I would move that we ought to pass with an amendment, and the amendment would make two changes in the bill. It would add well-being of the companion animal under A, well-being and basic daily needs of the companion animal. And in C, it would strike the word financially. Financially, I think, is implied with support, but I don't think this is about the largest bank account. I think it has more to do with the ability to care for the animal. And that might be implied under continue to own, support, and provide adequate care. So those are that's the motion. I hope to have support for it. Thank you.
Committee members, before we engage in discussion, is there a second on the motion? Representative Moriarty?
A second.
Okay, there's a motion and a second. And let's have discussion and questions. Representative Poirier, you may proceed.
Thank you, Madam Chair. I have a couple of questions just because of some of the testimony that came up in the hearing that we haven't touched on here yet. A couple of which there was concern about the definition of companion animal. We haven't addressed that yet. In the testimony of the Maine Veterinary Medical Association, it was brought up in the testimony that in the bill itself, it states the well-being of the companion animal. And in other statutes, it states cat or dog. But companion animal can actually be more than just a cat or dog when you come into these situations. So is that going to be addressed somewhere in the bill? And then the other question that I have is the liability for veterinarians. And that's a major concern that I have, because if you come into a joint ownership situation, the concern with the medical professionals is that if there is the major concern that was brought up by the association was in the case of a euthanasia, they can actually come into a situation where if it's joint ownership and there is a euthanasia in place and the other joint owner comes back to them, there could be malpractice situations there. Peggy, do you know if in other states how that is in their laws like this, or how that could be addressed?
Peggy, we are not able to hear you. And just to let you know, I was mute the first 3 times I said that to you. So
That's why I kept going.
I know, I couldn't figure out why.
It was my computer for a minute.
I thought I clicked it. Anyway, I have the Alaska and California laws in front of me, and I don't see that either one of them in that provision, because these are in family law sections, address that concern.
Which concern, Peggy? The
about the I'm sorry, the liability. If you're talking about the companion animal, I agree that sometimes, you know, we define things differently in different parts of the statute, and that can be confusing. This does say specifically for the purposes of the subsection. If you wanted, we could use a different term, and so it doesn't overlap with anything else. But I think it's clear that for the purposes of this subsection, companion animal is defined here. This is how the court will use it for determining the rights in this situation. If you want to change that definition so it's clear that it does include horses when they're not work horses, I mean, you can do that. But I guess it's nice to have consistent terms all across the statutes, but if this is what you want to do, I wouldn't worry about that being a particular problem. The other question about liability, I just have the family law statutes in front of me from California and Alaska, so I don't have anything about liability in front of me.
Yeah, that's my biggest concern is what was raised by the Veterinary Association, the liability issues that could come into play.
Let me turn to Mr. Fisk. He seems like he may actually be able to shed some light on this. And then Senator Chipman, if you'd like to weigh in as well, that would be fine. Go ahead, Mr. Fisk. And I think you might have 2 audio sources on because we sometimes have an echo. But go ahead. Oh, no, we can't hear you.
Okay now?
Yes.
Mm-hmm. Fine. Yes, thank you very much. I think I can help Representative Porter in her questions. First, there's a misunderstanding with the Veterinarian Association. There's no joint custody involved in this legislation. We specifically did that. So only one person would have the animal to make that decision as to who would take to the vet and pay for it and so forth. The other part you mentioned about companion animal, and we took a lot of time going over structuring that particular definition because there were concerns on both sides about what it meant in terms of what a companion animal is. And that's where we came up with an animal that's not a working animal, service animal, or farm animal kept for profit. Because the companion animal can be a horse, can be a rabbit, but we want to point out that in all the custody cases thus far, 90% of them have to do with dogs, and the vast majority of the rest of them have to do with cats. So a good friend of mine, Maris Pickford from Maine State Society of Protection of Animals, asked me about that. Are horses involved? And the answer is If it's a draft horse or it's a race horse, no. But if it's a companion animal is treated as such, then it would fall into this bill. So hopefully that helps you with those two questions.
I do just have one little follow-up, if that's okay, Madam Chair.
Yes, please do.
Thank you. With the Veterinary Association, the one point there that isn't quite in line was the fact that you're talking about custody when their concern is not just the custody piece, because the judge can issue custody, but the other person may actually have a bill of sale where they purchased the animal. And when it comes to a court case for malpractice or something like that, they may actually be looking at who by purchase of sale may own the animal. And that was the concern that the association had, so.
Yeah, I think that's more of a family law issue, actually having to do with the way property is disposed of in a divorce. And Peggy, can we rely on you again to address that this is not really it's not a kind of a custody determination so much as it is, it sounds funny to say it with regard to an animal, but it really is disposition of marital property.
Right, and the subsection starts out in the disposition of property. I assume that we're not talking about. I don't know what stops a court from ordering when property is divided that it couldn't still be owned by both people. So I don't know if you want to make it clear that in the disposition of the property, the ownership would end up with just one person to get to that question about having joint ownership. So that the court order should go over that bill of sale, because now it was part of that marital estate, and the court has ordered how that is going to be distributed. And if the court orders it to one person, then that it supersedes that bill of sale. If that makes sense. I mean, if you're dealing with real property, you have to record that in the registry of deeds. But if you're dealing with a car or a valuable vase, then the court order is what you need to show ownership, not anything that came before it. You would show that to the court, but coming out of the disposition of property, you'd have the court order. Is that clear?
I think so.
Yeah, I'm sorry.
Basically, they would show it, but the judge would make the determination if I mean, your receipt is more valid than where the animal should be placed.
Right. So then you have the court order, and even if the other person goes to the vet and says, "Look, I paid for this. I paid for this sheepdog." What overcomes that is the court order. And so whoever is taking the dog to the vet can bring the court order if there's any question and say, I've been ordered, this dog has been ordered into my possession. I own this now. And that should be sufficient for the vet to accept those persons' directions with regard to that animal.
Okay, thank you.
All set, Representative Poirier, for now? Okay. Representative Moriarty, I think you might be next. Go ahead.
Okay, thank you. Question for Mr. Fisk, if he's still available.
Yes.
And that is, Mr. Fisk, how do we know and where do we find that unless the parties agree otherwise, the court would actually give the dog or the cat to one of the divorcing parties and only to that person?
I'm sorry, I'm not sure I understand your question.
Okay, well, I think you said But of course, the court's going to give the animal to just one of the divorcing parties.
Yes.
The question is, how do we know that? Where do we see that? Where do we read that?
I'm still not quite sure. I mean, what do you mean, where do you read that?
Where's,
Let me just-
do you have
let me
a
interrupt
citation?
for one- Let me interrupt just for 1 minute, because I think that you may be asking a divorce law question that Mr. Fisk maybe isn't able to answer, and I see Senator Chipman looking like he might have an answer for
Well,
you.
he spoke with such confidence. I thought he knew the answer, but I'll defer.
Thank you. Thank you, but I'm not a lawyer.
So, Senator Chipman, did you want to answer that question?
I don't have an answer to that question. I was just nodding in agreement with the things that your analyst was saying previously. And no, I don't have an answer to where that would be found. And I don't have a background in law, unfortunately. Wish I did, but
Yeah, thank you. I mean, Steve, I can just give you my impression of how this would work, is that it talks about disposition of property. And again, it seems odd to talk about a beloved pet that way, but that like a toaster or a car, when judges enter decrees in divorce matters where parties have not reached an agreement on how property gets allocated, the judge makes a decision and assigns it to one party or another. And this isn't like a custody determination where the statute says you can order joint custody. This is still, even though we're inserting factors that focus on the well-being of both the animal and the people, it still is treating this in the decision-making rubric of a piece of property, which doesn't take you into that kind of joint ownership.
Okay, and I have certainly thought and hoped that that was true as well. But I just wanted to probe Mr. Fisk to see if there was actual statutory authority that addressed this. I gather I think you're probably right. It's implicit in the division of personal property.
Yeah.
Goes to one person.
Well, I think that's something that as a committee, we should discuss whether we want to, offer a friendly amendment to Representative Babbage's motion ought to pass as amended in order to clarify that, or whether we're satisfied that given that it still is in the classification of property, that we don't need to further amend the statute or the bill, excuse me. Representative Babbage, your hand is up, and Representative, go ahead.
Thank you, Madam Chair. Yeah, I'm not familiar whether joint custody is being given for pets currently. I mean, I'm not familiar either with a chair being given 6 months with one party and 6 months with another regarding property. But Representative Poirier brought, bringing up the veterinary concern again. I just wanted to ask a question because I'm not quite understanding. Whereas this proposal by Senator Chipman impacts or gives us guidelines for disposition of property, I'm not sure how I understand how veterinary liability is any different with passage of this bill than it is right now with any divorce proceeding and the disposition of a pet. I'm not understanding that we're creating a problem. Is that, are we doing that, or is the liability issue something that they would like to solve in the bill that they also currently have with whatever might happen in a divorce proceeding? I don't know the answer to that. I was really asking.
That's a good point. Representative Rackett?
I have to say, it feels to me like we're making a mountain out of a molehill. I mean, I think back to King Solomon and the great story about the, whose voice is that? We're going to divide this baby in half and give, half to one, half to the other. And the mother goes, no, don't slice the baby. So then he gives it to that person who says, don't slice the baby. I think the same is true of the couch. The same is true of the, who gets the stereo. I mean, I've been divorced twice. You haggle about stuff, you figure out who's going to get what. And then the judge says yay or nay. And I think that's what's going on. And I sorry to talk about pets like their property and that they're the same as a couch. I know they're not. Although occasionally my cat, when I have to save birds from him, makes me want to have him be a couch. But I think that it's really, I just think we're making too much of this. I think that the reason I like this is because it lays out a bunch of things that the judge should look at in order to decide the importance of these animals to the participants who are vying for their custody, essentially. And I like the list. I think it's a responsible list, and you wouldn't have to have such a list for inanimate property, but this is animate and it's loved property, and it makes it very different. So I think we shouldn't just make a mountain out of a molehill. I think we should just do this.
Yeah, I would love to add, Representative Rackett, I think you're so right. And also, on the issue of people working out disputes, if people who are having a hard time coming to an agreement understand what the factors are that the decision will be based on, it helps them get an idea of how the court would resolve an issue and moves parties toward resolution. And so I think that, I think this would be really, really helpful, getting people to agree and resolving disputes when there can't be an agreement. Members of the committee, does anybody have any additional questions or is there any committee discussion, additional committee discussion? Is the committee ready for the vote? Representative Moriarty?
Well, I was going to ask if there's any patience in drafting on the spot right now to address this question.
Which question?
The question of ownership, future ownership of the pet, to address the vet's concerns and so forth. I've just sketched out some language. I don't want to, everybody's tired, and if you're ready to go for a vote, that's okay as well.
Let's try us out with it, please.
Right. Here we go. Where it reads number 10, companion animals in boldface. The following language would read in this manner. In the disposition of property pursuant to subsection 1, the court, with respect to a companion animal, shall award ownership of each animal to just one of the parties based on all relevant factors, including but not limited to, and then A would be the well-being of the companion animal, and the other lettered criteria would follow in sequence.
Would you preserve Representative Babbitt's suggestion that we, in category C, get rid of the word financial?
Yeah, I'm fine with that.
Is there any discussion of Representative Moriarty's proposal? Senator Chipman?
Thank you. I think that sounds okay. I just wanted to make sure that was okay with Mr. Fisk, and I did sponsor the bill, at the request of him and the members of the Maine Friends of Animals. Just wanted to see if we could ask that's okay with what he thinks since they helped draft the bill.
I went through it pretty fast. I can do it again.
Mr. Fisk, is that okay? Is that language okay with you?
Yes, again, I'm not a lawyer, but if you are comfortable with it, given the conversation I am, I did want to mention, appreciate the amendment from Representative Babbage. Financially, it's okay. It does have a factor sometimes in terms of the well-being of the animal. Obviously, if someone's destitute and the other one has a lot more, in terms of medical bills and things of that nature. So I think it's an important criteria for the judge to consider, but I just throw that out to you. I can live with that amendment and appreciate it.
Thank you, Mr. Fisk. Representative Babbage, is your hand up anew or from previously? I didn't know if I'd missed you.
I'll lower it. I'm still pondering Representative Moriarty's. I might like that. I don't really think the two issues need to be addressed, but I could be amenable to this.
Okay, well, I'll come back to you. Representative Thorne, go ahead.
Thank you, Madam Chair. I missed what his Representative Moriarty's addition was. The pets concerns?
Yeah, would it be helpful if I screen shared the bill so that people could read it?
No, I was just curious what Representative Moriarty's addition was besides Representative Babbage's add well-being of companion animal on line A and strike financially on C. Was there another amendment that Representative Moriarty recommended that I missed?
Go ahead, Representative Moriarty.
Yes, I think Representative Thorne, you missed the most important part, which is that if the parties can't agree, and just parenthetically, if they can agree, that's fine. That's one thing less for the judge to do. But if they can't, this would specify that each companion animal upon divorce gets awarded to one of the spouses solely.
Yeah.
So that there can't be any question as to who owns the animal from that point forward. There can't be any question as to which vet is in the driver's seat. And it basically solves the ownership problem. But but utilizing all of these criteria, which take the characteristics of the animal and the relationship to the children into account. Now you wouldn't do that. You wouldn't do that for a chair, but you probably would for a family pet.
May I ask a follow-up question, Madam Chair?
Yes.
Only because, you know, I was thinking about the financial aspect of it. If the companion animal was a horse, I mean, obviously there is a lot of financial concern to consider if the companion animal was a horse. And you never want to rule out the size of the companion animal, but my sister went through that with a horse, and she didn't have the means to take care of it, but yet she wanted the horse because it was her horse, and she was going to make accommodations, but the accommodations weren't in place, and it wasn't a matter of being able to set them up. It was a matter of she didn't have accommodations for it. So just another thing to consider when financial comes in, that it may not be just a goldfish or a cat or a dog. It may be, you know, a substantial companion animal like a horse or something that considers a lot of financial responsibility. Thank you.
Thank you. Representative Babbage, is your hand up?
It is. It
Okay,
is, ma'am.
you may proceed.
Thank you, Madam Chair. If we have the well-being of the companion animal all by itself as a criterion, which may be Mr. Fisk's wish and Senator Chipman's, I would prefer that the emotional attachment provisions be primary. There may not be any priority list here, but I really think A and B should be D and E. And then the third item after the emotional attachments of the human beings involved would be the well-being of the animal itself, the basic daily needs of the companion animal, and the considerations, because many times the emotional attachment may not be determinable. But my support for this bill is really to try to take it out of being weaponized in the disbursement of property in a divorce. And so if we have if we have a man and a woman or whomever who love the animal, then the well-being of the animal should be primary, perhaps. But if we have one that is very, very much demonstrated a favored position regarding affection for the animal, I think that's primary over anything else, even including the well-being of the animal in some subjective measure. So I would be willing to take on the Representative Moriarty's amendment, but I would want emotional attachment of human beings to be the _1 criterion to be considered by a judge in the disposition of property. And so I'm hoping that'll be amenable to everybody else.
Yeah, I have a concern that we're as Lois said, making this, as Representative Reckett said, making this quite simple thing super complicated, and in the process we're going to lose both committee members who are able to continue to participate in the meeting, and also that we may have a multi-divided report. And so what I'd really like to do is to just have everybody take a moment to, so what we have currently takes the concept of the well-being of companion animal and adds it to subparagraph A in the factors. The factors are not in any kind of priority. Each one of them gets equal weight to the extent that they're relevant. And then in subparagraph C, the word financially is taken out. It still includes support and provide adequate care, both of which, of course, do take into account the financial capacity to some extent. I think that the underlying removal of that word financially wanted to, take away the fact that money might trump the other factors. And so that's what we currently have. Well-being gets added to A, financially comes out of C, and companion animal remains as it's defined in the final paragraph of the bill. That's what's before the committee. We can move to do the amendment suggested by Representative Moriarty, the reorganization suggested by Representative Babbage, or we can vote on the pending motion. And I would love the guidance of the committee as to how we should proceed. Who is ready? Representative Moriarty, you have your hand up, and I don't know, Representative Babbage, if yours is up anew or not. Representative Moriarty?
Yep, my hand is up for the purpose of asking Peggy whether she got all my language down or whether I should reread it for her benefit and perhaps for Representative Thorne's benefit and everyone's as well.
I think I have it, and I think I'd actually make a slight change to it, but I can read it if you want. I also know that Senator Carney had put some language together ahead of time, and I'm just wondering if it would be useful to, I know you don't want to delay voting on anything, but I wonder if it would be useful to have these things in writing in front of you to go forward.
Actually, it would.
Yeah, great suggestion. Representative Hagan?
I'm sorry, I must have hit the button by mistake. I am ready for a vote, but I was distracted, so I apologize. All set.
That's okay. Committee members, let's do a show of hands. I'm going to ask first who would like to table this and come back when we actually have language to look at. That will be the first, and then the second is who's ready to vote. So initially, who would like to table until we have language to look at? Please raise your real hand. And thank you, Representative Moriarty. And then who is ready to vote now? Looks like most of the members of the committee are ready to vote. So let's, Peggy, could you please read us the bill from the beginning through paragraph C with the amendments that you have? And I don't think we had a motion or a second on Representative Moriarty's language.
I believe you had a motion on Representative Babbage's language way back when.
We did, correct, and a second.
Yeah. Do you want me to just go ahead and read it?
Yes, please.
Okay. In the disposition of property pursuant to subsection 1, the court, with respect to a companion animal, shall award ownership of the companion animal to just one of the parties, considering all relevant factors, including but not limited to, paragraph A, the well-being and the basic daily needs of the companion animal. B, the amount of time each party has spent with the companion animal during the marriage, tending to the companion animal's nutritional, grooming, physical, and medical needs. C, the ability of a party to continue to own, support, and provide adequate care for the companion animal. So I took out, Representative Moriarty said ownership of each companion animal to just one party. And I think that because the whole thing talks about a companion animal, I think you would apply this separately to each companion animal. And that's why I would take out the word each, if that makes sense.
I think you nailed it.
Okay, so that is actually Representative Moriarty's amendment to Representative Babbage's amendment. And we just need to know if...
I so move.
And is there a second on that amendment? Seconded by Representative Reckett.
I will accept Senator Moriarty's amendment as a friendly amendment because we didn't separate A into A and B, so that's fine. Thank you.
And is the committee ready for a vote?
Yes.
Looks like everybody is very ready for the vote. Senator Chipman?
Quick question. So we're keeping the language that says that unless the parties can't agree otherwise, then that's when all this takes effect, right? So if the two parties agree that one person's going to have the dog on the weekdays and the other one's going to have them on the weekends, then that would still be allowed. But then if they can't agree, the judge would step in and apply everything here.
So that language isn't specifically in the bill, but that is part of the bigger framework of the disposition of marital property. So that's already understood.
Okay, great. Thank you.
Yeah. I think we are up. Representative Libby, go ahead.
Thank you. I just, in wanting to explain my vote, I think we really have to consider the burden on our judiciary. We have held hearings and heard what really excellent judiciary we have here in Maine. And I, with my vote, will just trust that they can use their judicial discretion to continue to help in this process. And particularly if we're talking about splitting custody in any way, I think we're looking at really overloading an already overloaded system. And that is why I will be voting on not to pass.
Thank you. And I did just want to clarify that the amendment that we just made does not talk about custody or sharing ownership of the companion animal. All right, I think we're ready for the vote. Representative Hagan, go ahead.
Thank you very much. I apologize. I got distracted with a phone thing and out there. So can you please just say quickly exactly what we're voting on again? Once again, I apologize on that.
We are voting on the motion ought to pass as amended. And do you need us to review what the amendments are again?
No, thank you. I just missed a few minutes of this and I wasn't sure if something happened. And I have a tendency, as I proved last week, to screw things up. So, so I was just hoping not to have to do that. So thank you.
All right, so the pending motion is ought to pass as amended. And Supi, you may call the roll. Thank you.
Thank you, Madam Chair. Senator Carney.
Yay.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Keim. Senator Keim is absent. Representative Harnett. Representative Harnett is absent. Representative Evangelos. Representative Evangelos is absent. 7 members voting in the affirmative, 4 members voting in the negative, 3 members, are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. Before we just have one last item, which I hope will be very quick on our agenda. Well, first of all, that closes the work session on LD 535. We have one bill that has been referred to us. It's LD 913, an act to enact the Maine Data Collection Protection Act. This bill on the surface looks like it might be the correct within the jurisdiction of our committee, but the text of the bill indicates that it is really about collecting, buying, and selling information from consumers rather than information that is collected and protected under state law. And so my request of the committee is that this is a bill that seems to be squarely within the jurisdiction of the IDEA committee rather than within the jurisdiction of our committee. However, since it's been referred to our committee, we need to vote as a committee to re-refer it to the IDEA committee. And so I would looking to the committee. Well, first I'm looking to the committee for a motion to re-refer LD 913 to the IDEA committee, and then a second, and then we can have any discussion. Representative Hagan?
Thank you very much, Madam Chair. I would be very glad to not have another bill that could go to another committee. So yes, or yay, as Mr. Thorne would
All right, so Representative Hagan has moved that 913 be re-referred to the IDEA Committee. Representative Poirier?
I could unmute. Yes, I second the motion.
All right, I think this is a nice note to end our busy day on. Is there any committee discussion? No, I'm not seeing any. Soupy, I think we're ready for the vote.
Okay, thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes.
Your
Representative
identity.
Representative Galgay Reckett.
Yes.
Representative Galgay Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Apologize on mic there. Yes.
Representative Hagan votes yes. Representative Libby. Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. Senator Keim. Senator Keim is absent. Representative Harnett. Representative Harnett is absent. Representative Representative Evangelos. Representative Evangelos is absent. I get 11 members voting in the affirmative, 0 in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. That closes the work session on LD 913, and it concludes our work for the day. Thank you, everyone, for hanging in there through a long day of very complicated bills. We did really great work as a committee today, and I hope you all enjoy your weekend.
Thanks, then.
Thanks, everyone.
Take care, everybody.
Have a good weekend.
Take care of yourself.
Congratulations, you just went from 132 bills to 131.
Yay.
See everybody Tuesday.
Yeah, take
Yeah.
care.
Bye-bye. Thank you.
Where'd Peggy go?